Good morning. Thank you all for being here this morning to have what I hope to be a very productive day on some really important issues. I want to welcome all of my fellow commissioners, all of the Global Markets Advisory Committee members, and a special welcome to not only our colleagues from the SEC, but our colleagues from around the world. There are a number of foreign jurisdictions that are here with us today, and I want to thank you all for being here. We were able to coordinate this meeting with an IOSCO OTC derivatives technical meeting, so we're very grateful that our foreign colleagues were able to stay and participate in this meeting today. I would also like to introduce Ron Filler, who's sitting to my left. He's formerly a long-serving member of the Global Markets Advisory Committee, and I want to thank him for agreeing to serve in the newly created role as outside chairman of GMAC. As the primary sponsor of the committee, I asked the Commission to approve this new structure to assist us with consideration of these very important global market issues. Ron currently serves as the director of the Center for Financial Services Law at the New York Law School and has been a valuable resource to the Commission for many years on futures issues. As we work to implement this new swaps regime, we are grateful for his continued commitment to this agency and to helping us formulate sound policy. For the past couple of years, the Commission has worked diligently with our colleagues domestically and internationally to coordinate our approaches to regulation of the global swaps market. We have all been eager to address the growing uncertainty brewing among swap market participants who were trying to decipher the extraterritorial reach of the Dodd-Frank Act. The CFTC has issued proposed interpretive guidance and a proposed exemptive order and has received numerous comments from market participants and other regulators. CFTC staff is working diligently to address the challenging issues associated with the statutory language of Section 2I of the Commodity Exchange Act and to incorporate the helpful comments we have received into any final Commission documents. Today, we're going to hear from Carlene Kim, who is our CFTC staff member leading this effort, and from SEC staff regarding their agency's work on these important issues. We're also going to hear from all of the foreign jurisdictions regarding their progress in implementing OTC derivatives reforms and any concerns they may have with achieving a global approach. It is my hope that today's meeting will provide the Commission with an opportunity to listen to all of the comments and concerns and to use this unique opportunity to ask any questions regarding the challenges to applying a sensible approach to these cross-border matters. This Commission has worked for decades to establish relationships built on respect and trust with our foreign counterparts. Global coordination is a key element to any successful regime to regulate the OTC derivatives markets. Again, I want to thank the SEC and all the other foreign jurisdictions for being here today to help us identify any conflicts with the cross-border application of Dodd-Frank so that we can accomplish harmonization with the rest of the world, both in substance and in timing. I now want to turn to my fellow commissioners for any opening remarks. Chairman Gensler.
I want to first thank Commissioner Summers for her leadership on these global and international issues and her leadership of this committee, and particularly Jill for bringing this committee together at this point in time. It is a very timely gathering, not only because, as she said, it links up with the meetings in the last 2 days of the international regulators, but also as both the SEC and CFTC consider some of these matters, these cross-border matters. As we know, the leaders of our various countries came together a little over 3 years ago in Pittsburgh in 2009 and made a commitment together to bring sensible, common sense reforms to the swaps and over-the-counter derivatives marketplace, and they actually set a deadline of December of 2012. So I very much appreciate Commissioner Summers bringing us together in November of 2012. But we really have all made tremendous progress together in Europe, in the U.S., in Japan, in major provinces in Canada. I know great efforts are going forward in Hong Kong, and Australia, and Singapore, and probably countries I've yet to name, on the key tenets that people laid out in 2009. Central clearing to lower risk, where we really are pretty much aligned. I know there's the devil's in the detail. Data reporting to data repository so that the regulators can have a better window into these markets. Public trading where appropriate, as the leaders said 3 years ago. And of course, risk mitigation that we have through so many capital and margin regimes. So I just want to thank Jill for bringing this together, all of you. This is a very time-sensitive matter because under our rules, a number of things do go into place early next year about registering as a swap dealer. So we'd like to, as best we can, take those thoughtful comments that Commissioner Summers said, the many, many market participant and regulator comments, and turn around the document. Carleen Kim is not getting a lot of sleep these days as the team lead. But there is now, I think, Carleen, am I right, in the last 2 days or 3 days, there's some documents in front of all 5 commissioners.
Yes.
So there's, and they'll change further, but there's documents in front of commissioners that are to try to publicly finish up this exemptive relief, the exemptive relief which is so critical that we had laid out, that certain rules would not take effect until we sort through many of these substituted compliance issues. And then secondly, trying to figure and finalize key parts of the interpretive guidance, particularly key parts as it relates to the definition of U.S. person, and some of the definitions around what might be entity-level requirements versus transaction-level requirements, take up some of the very thoughtful comments that people had laid out with regard to if one has to register, which affiliates within their organization would register, or something we call aggregation internally. But I think many people have raised very thoughtful comments. So we're going to try find consensus among the 5 of us as best we can to address the exemptive order and the key parts, particularly a definition of U.S. person, this aggregation issue, and some other issues, so that people can get some clarity here in the near term. But I look forward to hearing as much as I can today. I'll be with you part of the meeting. I do have a couple other things.
Thank you. Commissioner O'Malia.
Thank you very much for calling this very timely meeting, and I thank all of our participants, the international regulators, for flying to Washington to share with us your perspective on our rules and your rules. This day will be a very productive day, I suspect, and I know you've had two previous days that have been quite useful. And I look forward to reviewing those notes and meeting summaries, so I have a complete understanding of the discussions at the staff level. So I do thank you for coming. Welcome. You should have been here last week. No, you shouldn't have been here last week. You're lucky you weren't here last week. But let me just echo the comments by Chairman Gensler and Chairman Summers on this. We do need to make sure that we have agreement on these rules to make them effective. We cannot dictate to the world what our rules are going to be and expect you to adopt them whole cloth. I want to hear from you to understand the consequences of some of our rules and learn more about where your rules are going and under what pace. I do not want a unlevel playing field in terms of competition that puts U.S. banks or any other banks at a competitive disadvantage solely because of the rules. So we need to make sure that we clarify that. So I look forward to hearing more today, and thank you again for coming.
Thank you, Commissioner O'Malia. Commissioner Weejan.
Thanks, Commissioner Summers, and thanks for assembling this distinguished group. I think this will be a very useful and informative day for me. There's actually, I think, a fair amount of coordination that goes on behind the scenes, both between the regulators here in the U.S. and also with some of the foreign regulators that are here present. Maybe in some cases more than the public realizes, but there can always be more. And I think having a very public meeting like this, that comes on the heels of the last couple of days of meetings, real working meetings with the regulators present, is just more of what I think needs to continue to happen here over the next number of weeks as we try and coordinate our efforts here in the United States with the efforts around the globe, and completing our rulemakings and having them blend well with the rules of our fellow regulators around the globe. So I look forward to today's meetings. I think we've been reading with interest all the comment letters that have been filed in response to both our proposed exemptive order and our proposed guidance. And so I look forward to receiving even more information based on the dialogue today to supplement those letters. And I think all of it will be very, very useful as we decide what to do here in the coming weeks in terms of the application of our rules globally. So thanks very much.
Now I'm going to turn to our newly appointed Chairman, Ron Filler.
Thank you, Commissioner Summers. And I just want to use this opportunity to thank the Commission for appointing me as this chair of the Global Markets Advisory Committee. And I really, truly appreciate his confidence in me to hold this very distinguished position. I especially want to thank Commissioner Summers for thinking of me to be the new chair of GMAC. Commissioner Summers has done an amazing job as a chair of the GMAC over the past several years. And I look at my new role really as a partnership, a joint venture among Commissioner Summers as the primary sponsor of this committee, the GMAC members, and me in trying to lead the GMAC in the future. I also want to note that when Commissioner Summers contacted me a few weeks ago and asked if I would be considered to becoming the chair of GMAC, my first words to her then was that I was so deeply honored and humbled for her to consider me to be the new chair. Those words still apply today and will for a very long time. So thank you very much, Commissioner Summers, for thinking of me. For those of you who know me, I'm a results-oriented person. I'm a big believer that actions speak louder than words. And I really hope that we can use this opportunity among the GMAC members, the distinguished guests that we have here today, to try to lead and advise and counsel the Commission, because that, to me, is what an advisory committee should do, is provide advice, important advice and counsel, even offer concrete proposals to the Commission over time. I think we all owe a very special thanks to not only the 5 commissioners, but the very talented and knowledgeable staff here at the CFTC, many of whom I've known for over 20 years. Their contributions over the past 24 months exemplified their dedication to protecting the public with far too little resources and time in implementing the 60 or so rules required by the Dodd-Frank Act. We may not have always agreed with their philosophy or the regulations that they have adopted or proposed, but we all owe everyone here our sincere and deepest gratitude and should thank them all, the 5 commissioners and the entire CFTC staff, for the public service that they have so admirably provided over this period. Finally, I want to welcome our guests who have traveled from a far distance and who represent so many regulatory agencies around the globe. I am a professor, and I teach a course called Regulatory Policy in the LLM and Financial Services Law Graduate Program at New York Law School. And I strongly believe that our LLM students should not only know what the laws and regulations say, but the how and why that created them. In fact, this course on policy is so important that it's a required course for the LLM degree. So hopefully the discussions today on the cross-border guidance proposal will clearly reflect the varying policy differences that may and do exist globally. Commissioner Summers, your timing to call this meeting is excellent. So let's begin. And I do hope that the discussion today will be complex, challenging, energetic, and profound. And I know it will. Thank you again.
Thank you, Ron. Is it a requirement that your students watch the webcast?
Oh, absolutely. Grade depends on it.
So I'm going to start this morning with Carlene Kim, who is leading our team effort at the CFTC. She's going to give a presentation on the CFTC proposals. We're then going to turn to the SEC for Brian Bussey and Robert Cook to speak with regard to the SEC's efforts in these areas. But it might be helpful if we first, especially for those people who are watching the webcast, if we just ask that you go around the table and introduce yourselves and your affiliation so that everyone knows who's participating today. I'll start with Masa.
Thank you very much. I'm Masamichi Kono, or Masa Kono. I represent the Financial Services Agency of Japan, and I am also currently chairing the board of IOSCO, the International Organization of Securities Commissions. And thank you very much for your invitation.
Thank you very much and good morning. My name is Jun Mizuguchi. I'm the Assistant Commissioner for International Affairs, FSA Japan.
Good morning. My name is Hidetaka Nishizawa. I'm a Deputy Director for International Financial Markets, Office of International, JFSA. Thank you.
Hello, I'm Fabrizio Planta from the European Securities and Market Authority, ESMA, and I'm dealing with the post-trading issue at ESMA.
Good morning. I'm Nathalie Pission, working for ESMA and particularly on post-trading questions.
I am Peter Kerstens. I am the Finance Counselor for the European Commission at the EU delegation here in Washington.
I am Emil Paulis, Director of Financial Services at the European Commission.
Good morning, I'm Patrick Pearson and I work for the European Commission and I head the team that's responsible for derivatives regulation.
Carlene Kim, Deputy General Counsel, Office of General Counsel at the CFTC, leading the cross-border team at the CFTC.
I'm Brian Bussey. I'm Associate Director in the Division of Trading and Markets at the Securities and Exchange Commission, and I'm leading the team that's doing the cross-border proposal at the SEC.
Good morning. I'm Robert Cook. I'm the Director of the Division of Trading and Markets at the SEC.
Good morning. I'm Ken Nakatsuka at the MES, the Monetary Authority of Singapore. I'm leading the team on the legislative reforms for the OTC implementation.
Good morning, I'm Kenneth Gay from the Monetary Authority of Singapore as well. I'm also working on OTC derivatives reform.
Good morning, I'm Daphne Du, Director of Supervision of Markets Division at the SFC in Hong Kong, Securities and Futures Commissions, Hong Kong. Thank you.
Good morning, I'm Ryan Cole, Associate Director of the Securities and Futures Commission of Hong Kong in the Supervisions of Markets Division.
Good morning, my name is Oliver Harvey. I'm the head of the Financial Market Infrastructure team at the Australian Securities and Investments Commission.
Yes, good morning. I'm Christian Chaussé from Autorité des marchés financiers in Quebec, Canada. I'm Director of Derivative Oversight.
Good morning. Derek West. I also am at the Quebec Autorité des marchés financiers. I'm the Senior Director of Derivatives Oversight, and I'm also the Chair of the CSA, the Canadian Securities Administrators Derivatives Committee, working on these very issues.
Thank you all. I just want to go over a couple of housekeeping items this morning to remind everyone listening that the transcript of this meeting will be part of the public record on the cross-border issues, and that the comment period for public comments to this meeting will be open for 2 weeks, and that those comments will also be a part of the official record on these issues. I'll start with Carlene. Thank you, Carlene.
Thank you, Commissioner Summers. I'll spend the next 10-15 minutes allotted to me giving a broad overview of the two proposals with focus on some of the concerns raised by the commenters and issues that we are closely looking at as we finalize the two proposals. As you know, Section 2I was added to the CEA by the Dodd-Frank Act and provides that the Dodd-Frank swap provisions shall not apply to activities outside the U.S. unless those activities have direct and significant connection with or effect on U.S. commerce. Broadly speaking, the proposed interpretive guidance and policy statement describes the Commission's approach to interpretation of Section 2I as it applies to the Dodd-Frank swap provisions in the cross-border context. More specifically, the guidance addressed the circumstances under which non-U.S. entity would be required to register as a swap dealer or MSP, major swap participant, and the extent to which the Dodd-Frank swap provisions would apply to such registrants. It also provided a general framework for a substituted compliance regime under which the Commission would permit non-U.S. registrants to comply with the requirements of the home jurisdiction, the comparable and comprehensive requirements in its home jurisdiction in lieu of Dodd-Frank swap provisions. It also addressed the extent to which the Dodd-Frank swap provisions would apply to swap transactions between counterparties, neither of which are registrants. Before I get to the specifics of the proposed guidance, I would like to say a few words about the legal and policy rationale that informed the staff's thinking as it drafted the document. First, the staff views Section 2I as a clear expression of congressional intent that Dodd-Frank swap provisions apply to activities outside the U.S. under certain circumstances. These circumstances include situations where activities outside the U.S. have direct and significant nexus to U.S. commerce. In addition to the statutory text, we're also guided by the overall goals of the Dodd-Frank Act, which is to reduce systemic risk in the U.S. financial system and to avoid future financial crises. In enacting the Dodd-Frank Act, Congress was cognizant of the interconnected nature of today's global swaps market, and in particular that a firm's failure or trading losses overseas could quickly spill over and affect a U.S. firm and more generally the U.S. financial system. At the same time, the staff is very mindful of the Commission's obligations to consider international comity principles in exercising its authority to apply Dodd-Frank swap provisions to activities outside the U.S. Let me now turn to the U.S. person definition. This is a foundational element of our proposed guidance and one that has generated significant number of comments. As proposed, the term was intended to encompass those persons whose activities, either individually or in the aggregate, have direct and significant nexus to U.S. commerce. So in this respect, the term would include not only those entities or persons that are domiciled or organized in the United States, but also those that are organized abroad, but whose activities may have direct and significant nexus to U.S. commerce. In response to the proposed definition, commenters raised the concern that the proposed definition of U.S. person was overly broad, was ambiguous, and required data that they did not currently have available to them. In considering those comments, we recognize there's room for greater clarity, and there's a need to address certain implementation issues raised by commenters. And we're working very hard to address these concerns to the extent possible as we finalize the proposed definition of U.S. person. Another key element of the proposed guidance is the Commission's tiered approach to Dodd-Frank swap provisions. In the proposed guidance, the Commission proposed to divide, and this is largely consistent with the industry suggestions, into two categories. The first is the entity-level requirements, which would include requirements like capital, risk management, and these requirements would be applied on a firm-wide basis, regardless of the counterparties involved. On the other hand, we have in second category transaction level requirements, which would include requirements like clearing and margin real-time reporting, and these requirements would be applied on a transaction basis, meaning that it would apply, and the extent to which it apply would depend on the nature of the counterparties. And even where, in certain circumstances, even where Dodd-Frank requirements would apply, we may permit substituted compliance. Now let me turn to the various aspects of the proposed guidance that would apply to a non-U.S. entity, an issue I would think will be of particular interest to those sitting around the table. First, the non-U.S. entity would not be required to count swaps with non-U.S. counterparties or foreign branches of U.S. swap dealers in determining whether they meet the de minimis threshold. The exception is where the non-U.S. entity is guaranteed by a U.S. person. In that instance, the counting rules that apply to the U.S. person applies equally to that non-U.S. entity. Second, a non-U.S. entity need not count the swap dealing transactions of their U.S. affiliates when determining whether the de minimis threshold is met. But they would be required to aggregate the U.S.-facing swap dealing activity of their non-U.S. affiliates under common control. This so-called aggregation principle or concept is based on the aggregation principle that the CFTC developed jointly with the SEC in connection with the entity's rulemaking. And it was primarily designed to address concerns about evasion. This is also one of the issues that generated a significant number of comments from commenters, and one issue that we are, again, looking at very closely as we finalize the proposal. With respect to the entity level requirements, a non-U.S. registrant would be permitted to substitute the requirements of the home jurisdiction, but substituted compliance for SDR reporting would be allowed only if the Commission has direct access to such data. With respect to transaction level requirements, a non-U.S. registrant need not comply with these requirements when dealing with non-U.S. person, except where the counterparty is guaranteed by a U.S. person, or where the counterparty is an affiliate conduit of a U.S. person. But even in those instances, the Commission has proposed to recognize substituted compliance. Now, just a brief word on the affiliate conduit, because I see that it's listed in your afternoon's agenda, and it's, again, another of the more controversial issues that was floated by the commenters. The affiliate conduit concept was intended to describe those entities that act as a pass-through or conduit for one or more members of their affiliated, U.S. affiliated group. We were concerned that by virtue of the relationship between this foreign conduit and the U.S. person, and because the foreign conduit is in effect conducting market-facing transactions on behalf of the U.S. affiliate, that the risk associated with that market-facing transaction would ultimately reside with the U.S. affiliate. We were also concerned that affiliate conduit can easily be used to affect swap transaction outside the protections of the Dodd-Frank regime. As to foreign branches of U.S. swap dealers and MSPs generally would be subject to the same requirements of its U.S. head office. But with respect to transactions with non-U.S. counterparties, foreign branches would not need to comply with external business conduct rules and may substitute the requirements of the local jurisdiction for other transaction level requirements. Now let me turn to substituted compliance, again, one of the issues that is listed for discussion, further discussion this afternoon. In the proposed guidance, the Commission broadly described the process for and the factors that it would consider in making the comparability determination. A couple of notes to highlight in this regard. First, comparable and comprehensive does not mean that we're looking for identical regulations abroad. Rather, we would take into account all relevant factors, including the scope and objectives of the relevant regulatory requirements and the comprehensiveness of the foreign regulators' supervisory compliance program. Second, The comparability assessment does not entail a rule-by-rule analysis. Rather, we'll be approaching this on a category-by-category basis. So, for example, we will be looking at the capital requirements under our regime and compared to the foreign jurisdictions' capital regime. Finally, under the proposed guidance, with respect to non-registrant, they must generally comply with certain transaction level requirements such as reporting, record keeping, clearing, and execution requirement when at least one of the counterparty is a U.S. person. And with respect to SDR reporting, they may comply by reporting to a foreign trade repository so long as, again, the Commission has direct access to those data. Because we did not anticipate that the guidance, proposed guidance, would be finalized before the mandatory registration date, and because we do have certain Commission rules implementing Dodd-Frank provisions still in pending status, we propose to give temporary conditional relief to non-U.S. registrants as well as the foreign branches of U.S. swap dealers and MSPs operating overseas. Generally speaking, and very broadly speaking, under the proposed temporary relief, non-U.S. registrant may be permitted to delay compliance with entity-level requirements until July of next year. Similarly, for transaction-level requirements, with respect to transactions with non-U.S. counterparties, they may be permitted to delay compliance with transaction-level requirements until July of next year. Finally, in closing, let me just update you on the status of the rulemakings. As the chairman mentioned, both proposals, the proposed exemptive order, the finalized version of it, as well as some aspect of the proposed guidance is currently under review by the commissioners. The final draft, proposed exemptive order and the guidance reflect a very careful consideration by the staff of over 200 comments that we've received from commenters on the proposed guidance and close to 30 comment letters on the proposed exemptive relief.
Thank you, Carlene. And now I'm going to turn to Robert and Brian for any comments that you may have. Thank you.
Thank you, Commissioner Summers, and good morning, Chairman Gensler and commissioners and members of the advisory committee. Thank you very much for the opportunity to be with you this morning and to share with you a little bit about where the SEC is in the overall process of implementing the security-based swap provisions of Title VII, and a little bit about how we expect to address the cross-border release, the cross-border issues in a release that the Commission staff is currently working on. Before I go any further, I need to state that as a matter of policy, the SEC disclaims responsibility for statements like this by SEC employees, so the views I express today are my own and do not necessarily reflect the views of the SEC, the commissioners, or my colleagues on the Commission staff. So first, where are we in the process of implementing Title VII? The SEC has now proposed all of the major rules required by Title VII for securities-based swaps, and in some cases has adopted final rules. As you know well, we've adopted jointly with the CFTC certain definitional rules relating to swap dealers and major swap participants, and rules and interpretations regarding the products that will be subject to Title VII. The SEC has also adopted rules relating to the security-based swap clearing infrastructure, including standards for risk management and operations of clearing agencies, and rules regarding the process for making mandatory clearing determinations. In addition, to help ensure that the system is implemented in an orderly fashion, the SEC issued a policy statement in June describing and requesting comment on a roadmap setting forth the anticipated sequencing of compliance dates for when the various Title VII rules will take effect. The goal of the policy statement is to avoid unnecessary cost and disruption that could result if compliance with all the rules were required simultaneously or in a haphazard manner. More generally, the policy statement is part of an overall commitment to making sure that market participants know the rules of the road before compliance with those rules is required. The statement emphasizes that those subject to the new regulatory requirements arising from these rules should be given adequate but not excessive time to come into compliance with them. Market participants provided us with a number of very useful comments on this roadmap, and we're taking them into account as we proceed toward the adoption process for the rules that have already been proposed but have not yet been made final. As the Commission has worked through the process of proposing these rules, it has, generally speaking, not addressed the cross-border implications of them. Our chairman has indicated on a number of occasions that rather than addressing the cross-border issues in a piecemeal fashion in the context of each of the various substantive rulemaking proposals implementing Title VII, the SEC is instead planning to address the international application of Title VII holistically in a single proposing release. We believe this approach will provide market participants, foreign regulators, and other interested parties with an opportunity to consider as an integrated whole the SEC's proposed approach to the application of Title VII to cross-border transactions. In terms of timing, I would anticipate that the cross-border release will be published in the next few months, and in any case, before the substantive rules such as registration, trade reporting, and the like that are discussed in the release are finalized, so that comments received on the cross-border release can be taken into account in drafting and finalizing our recommendations for the final rules. In other words, we do not intend to recommend that the SEC finalize rules that have a cross-border effect without first addressing the cross-border implications of those rules as well. We found the exercise of preparing this cross-border release to be very difficult and a substantial undertaking for a number of reasons. I would wager that this will probably be the longest document we put out under the various Title VII rulemakings. Why is this? Well, first, we're doing it as a rulemaking proposal rather than as interpretive guidance. And as with any rulemaking proposal, in addition to considering issues such as reducing systemic risk and the protection of investors, it will also include a full cost-benefit analysis and discussion of the effects of the proposal on efficiency, competition, and capital formation. Second, the scope of the rulemaking proposal is very broad. In the rulemaking, the staff will recommend that the Commission address the cross-border application of Title VII with respect to all the major registration categories, such as swap dealers, clearing agencies, data repositories, and swap execution facilities. And will also recommend that the Commission address the cross-border application of the Title VII requirements in connection with the various substantive provisions of Title VII, such as trade reporting, trade dissemination, clearing, and trade execution. Third, and probably most importantly, we're very conscious of the challenges associated with imposing a new regulatory regime on a pre-existing market, which raises a number of novel issues for us. In traditional securities space, the SEC has a long history of addressing cross-border issues going back well over 40 years. However, unlike in the traditional securities markets, the SEC has had the opportunity, where the SEC has had the opportunity to consider cross-border issues gradually and incrementally. The Dodd-Frank Act requires us to impose a completely new regulatory regime all at once on a pre-existing market. These challenges are heightened in the context of the securities-based swap market because of its global nature. The securities-based swap market currently operates relatively seamlessly across jurisdictions, with transactions often being negotiated and executed between counterparties in different jurisdictions, but booked and risk managed in still other jurisdictions. In this space, cross-border transactions really are more the rule than the exception. And let me try to share with you a little bit of detail on that, because I think it's important for understanding the challenges we're facing. We have some data available to us from the trade warehouse about transactions in 2011. Most of the securities-based swap market consists of single name or small number of names of credit default swaps. So the CDS market is most of the securities-based swap market. And this data suggests that most of that CDS market is cross-border in nature. By some estimates, more than half of trades involving a U.S. reference entity had at least one party that was foreign domiciled. And looking at it a different way, if you look at all single name CDS, there's a relatively small percentage that actually involve only 2 US parties. So in most securities-based swaps, there is a cross-border component. So when we're talking about the cross-border application of our securities-based swap rules, we're really talking about the application of our securities-based swap rules in general. And so that's very much informed our thinking and approach to some of the challenges here. And also, in our view, requires that we think about a number of factors in addition to reducing systemic risk and protecting investors. For example, we need to consider and appreciate foreign regulatory frameworks and principles of international comity. We also need to avoid creating opportunities for cross-border regulatory arbitrage or competitive imbalances. And we also need to think about and avoid unnecessary duplication of rules or conflicting requirements. How do we go about doing that? Well, we've been working hard with our fellow regulators in other jurisdictions and with the CFTC staff through various discussions and participation in various international task forces and working groups to help identify the possibility of gaps, overlaps, and conflicts between our rules and foreign regulatory regimes. In addition, in order to help promote greater coordination with the CFTC and our fellow regulators, our staff has prepared and shared with the CFTC and other regulators fairly extensive and detailed charts indicating our staff's current thinking about how the various requirements of Title VII might apply to cross-border transactions involving different types of entities. These charts would address, for example, potential approaches to U.S. persons, to guaranteed entities, to substituted compliance. And the purpose is to help facilitate greater coordination and to strive for consistency and to solicit comments from our fellow regulators so that we can incorporate those into the recommendations that we ultimately give to our Commission. We intend to update these charts. It's an iterative process. As we get comments on them, we'll provide you with new versions of them as our thinking evolves and as we get comment from both the CFTC staff and other regulators around the world. And of course, with all of our Title VII releases, we'll be sharing with you drafts of our cross-border release for your consideration and comment before it's published. So with that, let me draw to a close and thank you again for the opportunity to chat with you about where we are in the process of addressing the cross-border issues and to thank you for your continued cooperation and support as we try to implement these provisions of Title VII.
Thank you, Robert. I'm now going to move to the presentations from the foreign regulators that have joined us today. I'm going to start with Masa, and then as we go around the table, hopefully we'll have time for questions from the Commission at the end.
Thank you, Madam Chair, distinguished members of the CFTC, and also certainly the distinguished members of GMAC. It is my great honor and pleasure to be here with you today. I have a set of slides here, and within the permitted time, I would like to take you through those very quickly. I have 2 disclaimers to make before I start. The first one being that, of course, I do represent the FSA of Japan in various international meetings, but what I mentioned today should be attributed to myself, but not necessarily to the JFSA. Also, I do chair the International Organization of Securities Commission's board, but again, what I've mentioned today is not the official views of the IOSCO board. The second disclaimer is that since I got off the plane this morning, I hope I can be clear enough, and please excuse me if you don't find myself too up to speed with your concerns. I'll try my best. And of course, I should start with this slide, which reminds you of the fact that this is very much a collective commitment of the G20 countries, as, of course, Commissioner Summers mentioned at the outset, and the other commissioners have also emphasized. That is, first and foremost, I should mention that we would like to commend the CFTC for its hard work in actually meeting those requirements, and certainly you have been one of the first regulators in the world to have actually implemented those rules or started to have to implement those rules. And we, of course, would like to be up to speed with your efforts, but whatever I mentioned later will in no way be critical of the sincere efforts that you have put into this work. So I would like to emphasize that. Now, in Japan, what we have been doing, and of course, in line, very much in line with this G20 commitment, is that we amended our law in 2 stages. The first stage, which was approved back in May 2010, and in this piece of legislation, we have actually enacted a mandatory central clearing requirement at CCPs, and also reporting requirements to trade repositories. And those requirements have actually been implemented as of November 1st of this year. But later on, I will touch upon some flexibility that we have put into our law or the implementation of the law to accommodate any international arrangements that we will be making, and we had better do it fast, of course. The second stage legislation was approved this autumn in September of this year, and in this we have a mandatory use of electronic trading platforms, which will be implemented in a phased approach up to 3 years. For the initial stage and for central clearing, we have at the outset limited the application of this requirement to index-based CDSs and Japanese yen-denominated interest rate swaps with reference to yen LIBOR. Now, we have also limited at the outset this requirement or mandatory central clearing requirement to transactions between large domestic financial institutions who are members of licensed clearing organizations. And this is, of course, being mindful that currently in our country there is only one licensed CCP under our amended law that qualifies for as a designated clearing organization. On trade reporting, we have a requirement to report to TRs the OTC derivatives transactions for which TR services are available. Again, here we have adopted a very much a pragmatic approach where, of course, we will not ask for some things that are impossible to comply with. Examples of such transactions are credit derivatives transactions and forward option and swap transactions with reference to interest rates, foreign exchange, and equities. Now, you realize that this is much broader than the central clearing requirement, of course. But again, this is very much in recognition that there are trade repositories or trade repository services already available beyond our borders. That is, our institutions can certainly have recourse to TR services outside Japan. This is just a timeline for the implementation in Japan of those requirements. Mandatory central clearing, as I mentioned, became effective on November 1st, so has the reporting requirement, and the use of electronic trading platforms will be for a later stage. Now, this slide could be controversial in this country, and I will have to mention that we have already heard from our colleagues at the CFTC that many of those issues are being addressed. So please take this as a rather rough summary of the issues that we have identified in the course of our study or analysis of U.S. rules as we saw them up to this summer, but not necessarily as of today. when, of course, our firms have started to realize that they are facing this registration requirement as a swap dealer in the U.S., and they are non-U.S. persons, they have found that, of course, the details and the exact requirements within the cross-border rules and guidances have not been finalized yet, and they would certainly like to see more clarity in the requirements that they will face when, of course, they have to register. So the first item is really a request for more clarity when eventually they register as a swap dealer under the U.S. laws and regulations. Second, as it was referred to already, substituted compliance. We certainly appreciate very much this concept, and the implementation of this is extremely welcome from the point of view of a non-U.S. firm or a non-U.S. regulator. But of course, we would like to see more clarity, and we also, of course, would like to see some assurance that we, as a regulator, would also qualify as being applying equivalent rules or requirements on the OTC derivatives transactions at issue. The third item, cross-border transactions subject to duplicative requirements for central clearing and data reporting. On this, of course, each regulator faces this issue because, of course, by nature, those transactions have their legs in different jurisdictions. In our country, at the outset, we have simply refrained from applying our rules to cross-border transactions in anticipation of an international arrangement to be worked out very soon. And within a year or 2 years' time, we will apply our rules to cross-border transactions when such arrangements are made between regulators on how to apply the respective rules to cross-border transactions. Foreign CCPs not recognized under U.S. regulation. Again, this is in particular with regard to CCP that we have in our country, which is now seeking a license with the CFTC. Now, of course, since they are relatively underdeveloped and have not been in business for a very long time, certainly this is quite a challenge for the CCP and also for the regulator, of course, because we would like to have this CCP be world-class and certainly a state-of-the-art operation as compared to, of course, the much larger and sophisticated CCPs in the US and Europe. The last point, of course, this may not be a fair point, but we would like to see, of course, common rules applied by both commissions, the CFTC and the SEC. And certainly I understand that such efforts are being made, but of course, our request will be that this process is speeded up. Now, of course, we would certainly like to be constructive in contributing to those collective efforts, and therefore, from our side, JFSA and the Bank of Japan, we have sent you a joint comment letter in August of this year. And then, of course, a joint ministerial level letter has been sent in October with a focus on cross-border issues. The signatories of the ministerial level letter are as follows. In the joint JFSA-BOJ letter, we raised two overarching concerns and some specific ones that will follow. But the overarching concerns are I would like to think that this is a collective will to avoid overlapping or conflicting regulation and need for international coordination in cross-border regulation. I don't think there's any disagreement here. It's just that, of course, we have much more to accomplish in the very near term. Specific requests, this will be somewhat duplicative with the earlier slide. That is, we would like to see the concept or the formulation of substituted compliance being extended further and be clarified further as well on procedure and timing as well. Deferral of application of CFTC regulations with respect to non-U.S. persons. Well, of course, we are very much under this G20 commitment, but at the same time, we would like to have your understanding of a non-U.S. person having difficulties going through, of course, each and every requirement under Dodd-Frank and your regulations, and that they would certainly appreciate very much some more time to prepare for complete compliance with those rules. The last point is exclusion of certain transactions from the calculation of swap transactions in regard to the de minimis threshold for non-U.S. persons. This is somewhat technical, but for the firms concerned, of course, the calculation of this of the swap transactions that they have entered into is already a challenge, particularly when you have to actually look at all your affiliates and branches around the world and whether they are in transactions they have entered into transactions with U.S. persons, and as it was mentioned by our CFTC colleague, whether, of course, they would in effect be giving direct and significant effect on U.S. commerce or having a direct and significant nexus to U.S. commerce. In effect, well, I would like to characterize the issue really as a coordination issue, but then there's also, of course, a certain issue of sequencing of the reforms, and this is just to reiterate that while, of course, those registration requirements have already entered into force, basically, and that non-U.S. persons have only up until the end of this year really to prepare for registration, there's a lot, of course, that we would like to see in terms of clear and final rules before such requirements come into force. And we can certainly understand that the practical difficulties of properly sequencing them and perhaps doing this all at once. But at the same time, we would like some consideration of, again, the difficulties that non-U.S. persons certainly have to face in looking at those rules, making an analysis of how those rules affect their businesses, and then, of course, be able to prepare. I must say that there is certainly a sense of considerable uncertainty in the markets at this point in time. And well, this is really a reiteration that the non-U.S. persons are really facing challenges in terms of preparation and in some cases potential conflicts and inconsistencies. And here I do have a relatively strong statement that major reductions in market liquidity and or shifts in transaction venues could occur. But I think this is part of reality that this is starting. And I have actually heard some firms outside of the U.S. who have started to decline transactions with U.S. counterparties because of the uncertainties in the rules, and also the apparent lack of coordination between regulators. For transaction level regulations, one particular issue that I would like to draw your attention to is that if there is no single CCP which is licensed or registered both in Japan and the US for example, Japanese yen-denominated interest rate swaps, market participants really would find themselves in breach of either the regulations of Japan or the US when, of course, our rules apply to cross-border transactions as well. Now, we have very deliberately excluded cross-border transactions from the scope of application of our rules at the outset, as I mentioned earlier. But this is not at all an ideal situation, of course. Certainly, in order to meet the G20 commitments, certainly we will have to apply our rules to cross-border transactions as well, with one leg in Japan, of course. But then what will happen is that if there's no CCP that is commonly recognized in both the US and Japan, there will be a problem. And there is one CCP, again, that is seeking CFTC regulation registration at this point in time. Now, when it comes to the actual inspection and the day-to-day supervision of the CCPs, of course, we would like ourselves to be recognized by our U.S. counterparts or our colleagues in at the CFTC, so that, of course, each authority will be the primary regulator of the CCPs established under its own laws, and, of course, in close coordination with their foreign counterparts. Trade execution requirement, well, when those requirements come into place in countries, of course, the same kind of issues will arise. Entity level regulations, again, there will be overlaps of those requirements for those firms that actually conduct transactions cross-border and then operate in multiple jurisdictions. And examples here are such as head offices of Japanese financial institutions registered as swap dealers in the U.S. or subsidiaries and branches in Japan of U.S. financial institutions. They will be facing such issues. Data record keeping and reporting, etc. Again, we would like to see more coordination. Of course, when I say we would like to see, of course, we also have our own obligation to follow through with such coordination, and we are certainly ready to discuss this much more in detail. And we would like ourselves to be, again, recognized as the primary regulator in this area as well. So this is very much a very quick presentation of the issues we are facing. We do hope that we can work collectively and in good faith to achieve a common goal, and certainly we are partners. And thank you very much again for giving us this opportunity.
Thank you so much, Masa. We're now going to turn to ESMA for their presentation.
Thank you, Commissioner Summers, and thanks for inviting us in this important committee. I will try to be short in view of the fact that both ESMA and the European Commission will talk for Europe. So we'll start by updating on the EU regulatory reforms, where EMIR, the primary legislation implementing the G20 mandate, was adopted on the 1st of July and entered into force on the 16th of September. But most of the provisions to actually take effect requires technical standards to be developed by ESMA. And those draft technical standards has been delivered by ESMA in its final form to the European Commission on the 27th of September. And now the Commission is expected to endorse them hopefully without modifications, by the end of the year. This means that the entry into force of the entire framework in Europe is expected at the beginning of the year. But the actual application of the different provisions gives on average 6 months after the entry into force to give the time to market participants to adapt to comply with the new requirements. Of course, there are differences in the different provisions, but that is basically on average. Of more than 40 technical standards that ESMA has delivered to the Commission, 2 were not delivered. And these 2 were one on bilateral margins, to take into account the international work of the WGMR in that respect. And the second one is to define what are the contracts between third country entities that have a substantial foreseeable effect within the EU. And the reason for postponing that is very much linked to the discussion we are having in these days and in the past months with the international colleagues. And this leads me to the European approach to third countries. And this approach is very much based on equivalence. ESMA has received a mandate from the European Commission to issue a technical advice for assessing the equivalence of different jurisdictions in 3 areas. Basically, the OTC derivatives area, so clearing obligation, risk mitigation techniques, the CCP requirements, and the trade repository requirements. And we will need to issue this technical advice early next year. And the assessment that will be carried out will basically follow this principle. It will need to be objective, it will be holistic, and will be focused on the outcome rather than on searching for exactly the same provision in the third country. And I would like to stress the benefits of the equivalence approach compared to a registration and substituted compliance approach. The benefit is that there is one set of rules that always apply, that basically the EU rules can disapply in all cross-border cases in case there is a third country equivalent. So the risk mitigation technique, the clearing obligation under EMIR can disapply, and the market participants can choose which regulation to comply with if the 2 regulations are equivalent, and which infrastructure to be used if also the CCP is recognized. And for the recognition, the basic requirements are the equivalence of the regulatory and supervisory framework, and the establishment of a cooperation arrangement between ESMA and the third country authority. And this is essential because in Europe we will basically rely on the supervision and enforcement of the third country. If we recognize an institution, is not like registering, we will fully rely on the supervision of the third country authority. And this is why it is important to have this cooperation arrangement in place. Now, turning to how we see the US approach developed so far, and making the difference between equivalence and what we have seen, is basically what the main issues and concerns that we have identified are that there is first a requirement to register, and then there is uncertainty on which rules will apply, on which cases, The substituted compliance can apply, but not on all cases, certainly not on the cross-border cases. So at least what we see as a cross-border cases, because for us, it is pretty clear what is a European entity, and that is an entity established in Europe. In all the cases where there is a U.S. person, or whether established in the US or not, and the European cases, these are all cross-border transactions in our views, and in all these cases, the double regulation can apply, because basically Dodd-Frank is, for the time being, not be seen to disapply. And so if we also do not disapply EMIR, basically this transaction will not be able to be concluded by the counterparties. Basically, this is another major element of the of this approach is that basically the registration gives by definition, and this is something that, I mean, it's a different way of seeing things, but differently to the recognition, will basically give the jurisdiction of the U.S. authority over a third country authority, over a third country counterparties, and that means that that authority can decide either to disapply substituted compliance, to apply it only on certain elements and not on others, to directly enforce the requirement instead of relying on the cooperation of the third countries. So what are the consequences of this approach that we see, at least the major one that we see? First, a very high compliance cost, because the third country counterparties will be subject to two or multiple set of rules to comply with it, and they will need always to monitor which one will apply and whether the two can apply if they are not conflicting, and two or multiple competent authorities to be subject to, again with substantial compliance cost. But more than the compliance cost, the problem is really the impossibility to conclude certain transactions because of conflict between the two sets of rules. And where does these conflicts arise? Why do they arise? They arise because of different definitions, swap dealers, major swap participants, or financial and non-financial counterparties, different scope of application of the different rules, different exemptions. And so what happens if in one jurisdiction there is an exemption and in another one there is not, and the same entity is subject to the two set of rules? Does the exemption apply or not? In which cases, depending on which counterparty it faces? These are all questions that are still unresolved. And so different determinations on the clearing obligations, again, can give rise to conflict, and different CCPs to be used, as Masa Kono was mentioning. If there is no common CCP, basically the clearing obligation cannot apply, or in one jurisdiction there would be a clearing obligation, in another one bilateral margins. These are all issues that can arise. Basically, if I may make a parallel to a sport situation, it's like asking a player to be at the same time in two different fields, or if we consider the global derivatives market as a baseball field, is like deciding which rules apply depending on the player that hits the ball. This is not workable, and we as international regulators have the responsibility to find mutually acceptable, workable solutions to solve these issues.
Thank you so much. And now I'll turn to the European Commission, Emil.
Thank you very much, Commissioner Summers. Thank you for the invitation to the European Commission to this roundtable. When I took my hotel room at the reception, they told you, Mr. Paulis, you will have the room 722. So by that time, I realized how powerful the CFTC can be. I landed in the room 722. I thought it was splendid. This was the right room to be to continue to prepare for this meeting here. Thank you very much. This is really what happened to me. It's not an invention of mine. I'm not going to repeat what my friend Fabrizio said very clearly, but just to emphasize a few important messages, I think, from our side, which I think we really want to highlight. First of all, in the EU, we have a robust and comprehensive framework in place, which is EMIR. It covers mandatory clearing, mandatory reporting. We have in other parts also the capital requirements. And as you know, there is no doubt, I just want to make this clear, there's no doubt that in Europe, with the revision on MiFID, we will have mandatory trading. So we are really completely, with some delay compared to the US, we are completely on track with a full implementation in the field of derivatives. We fully share the objectives of the G20, and we fully share the objectives of all our fellow regulators here to ensure that there's no loophole, that there's a seamless safety in the system. So that is what we have already. And I think this is the other point which I want to make in that respect is that when we compared our rules with the US rules in particular, we found out that quite often our own rules are even stricter than the US rules. And it is interesting probably for the other jurisdictions, if they look at the table of comparison of the two rules, they can pick and choose the best practices, basically. the rules which in an alternative way, try to achieve exactly the same objective. But that is important. Two, the derivatives market is, of course, a global market, a hugely important global market. If any field in which we have to succeed, then it is on banking and on derivatives. Banking, Basel III, here, derivatives. These are the two fields where we G20 members are being watched and where we need to deliver. So we are fully on the camp of those who want to deliver on that. And this market is so global and so important, over $600 trillion, that we think that none of us can succeed to control this market by himself. It is impossible, even for the most important jurisdictions, to think that they can control this market, even by having a very far extraterritorial application of the rules. It is not possible to master the systemic risks in that market if we are not joining up forces here. So that is the importance of the work of the G20, and that is the importance of the discussions which we have amongst the regulators. I also want to stress that this work which we are doing is not about a maximum extension of our respective national laws. That's not what it is. We don't want, none of us, neither the US, nor Japan, nor Hong Kong, nor the EU, none of us wants to show we want to apply our law as far, as wide outside our territory as possible. No, it is about closing loopholes. It's about ensuring that we get safety in the system, that we are protected against contagion. So for me, this cooperation between the regulators is absolutely key. United we stand, divided we will fall. That's for sure, because we are convinced that even if any one of the jurisdictions was to believe that it could really control every corner of risk, which can be the source of contagion, it will fail, and it will get affected by that failure. So we need to be very conscious, and therefore we think the only way to effectively supervise is cooperation. It is close cooperation between the regulators, and not that one single regulator would think that he could achieve that goal. In the EU, we have created ourselves a means of this international cooperation. We have in our statute a full substituted compliance regime which is applicable to foreign jurisdictions, where, of course, these rules, the rules of the foreign jurisdictions are comparable. Now, this is, in our view, the right way to go, because it creates legal certainty, it creates a workable system for these different laws to speak to each other, and it allows precisely effective supervision. So, in our view, it is important that we discuss how we can make progress on that front. We are also of the view that when the G20 decided to impose mandatory clearing, that it is a novelty. It's a huge novelty which we introduce in this market, and that it is quite important that we do not add to that mandatory clearing obligation, the new obligation, other obligations which are not absolutely necessary. And that means that we should try to avoid the application of multiple rules where it is not necessary to have multiple rules applicable. That means we should try to use as much as possible, as Commissioner Summers said, respect and trust between jurisdictions. We must build it up, of course. And then, on that basis, that we rely, that we defer to a broad substituted compliance regime, a broad equivalence regime, a broad recognition regime, but which remains a responsible one. We don't want to create loopholes in the system. But here the point is, and Fabrizio made it, the huge advantage of that is that one set of rules is applicable. That creates legal certainty. That creates a system which is acceptable also in the daily work. I want to stress this. Why? Because before I worked in the field of competition. In the field of competition, you have rules which we call prohibition rules. It is not permitted to have an abuse of to commit an abuse of a dominant position. It is not permitted to enter into a merger which leads to monopoly. These are prohibition rules. You can accumulate prohibition rules over several jurisdictions, and the strictest rule is then applicable. That can work. But where you have a system like we are creating here with not prohibition rules, but mainly rules which impose obligations to do something, and there are many, there are hundreds of them, massive rules, we must admit that as regulators, you, we, all our jurisdictions, we have to close all these loopholes with many obligations to do something. If in that scenario we finish up with multiple rules applicable, and it is always the strictest rule which is applicable, that adds up so much burden in the system that it shoots far beyond what we are trying to achieve, far beyond. It creates an undue burden, and it leads to the fact that we regulate, it's nice to do so, but that we regulate so much which is not necessarily required to ensure financial stability in the market. But again, I am a strong defender, and the Commission is a strong defender of ensuring that there are no loopholes. So we have to focus on that, of course. Now, we have, of course, in Europe, a similar provision to your 722. But the whole philosophy, I take it, of the Dodd-Frank Act and also of EMIR, is not to apply our rules to foreign entities. It says in Dodd-Frank Act, in principle, it's only applicable to US persons unless, and then you have the issue of, we come back to that, you see. We have the same. So it's only by exception that it is provided in our statute that one may apply the rule to entities which are not resident or not established in your jurisdiction. And I think that is correct. The purpose of that set of rules, your 722 and our rule, is not to expand the reach of regulation. It's not to expand the reach of supervision. It is there to avoid evasion, and it is there to ensure that we have safety in the system, that we close the loopholes. That's why it is there. And therefore, we have to be reasonable and proportionate and to limit it really to the essentials. Now, what are our concerns, not specifically addressed to the US, but for us as well and for all jurisdictions? These are common concerns, because we need to succeed here for the common good. The concerns are, you can already deduct from what I just said, that we should all try to reduce the extraterritorial reach to the minimum. We should try to reduce it to the minimum. And we should try to take account of the fact that in a number of jurisdictions you have already rules applicable. So let me take the registration case. The obligation to register. In Europe, we have, well before Dodd-Frank Act, we have an obligation for our firms to register. MiFID I, which is in place. So we have MiFID, we have EMIR, we have CRD on capital requirements. We have it all. So it is quite questionable why, therefore, those firms which are already registered in a responsible jurisdiction with a fully fledged set of rules now has to add another registration in another jurisdiction and then a third registration in a third jurisdiction, and we go on and on and on. I think that's not what we want. What we want is that there's an obligation of registration in those jurisdictions where there is either no regulation or where there's a really materially non-comparable regulation. Because then it matters. We can't just accept that we deal, therefore, on the same footing with those jurisdictions. And I would pretend that we should focus our efforts much more on closing the loopholes vis-à-vis jurisdictions which are not sufficiently regulated, rather than extending far the reach of our rules between jurisdictions who are committed to really implement in a serious way the G20 commitments. So these are really some of the major. Then a last point which I want to stress is the following. Substituted compliance or equivalence. That is not a downward sloping route for soft enforcement. If it was, then we cannot accept it. You cannot accept it, we cannot accept it, you cannot accept it, you cannot accept it. So substituted compliance, we must give it a meaning, a serious meaning. And that means that it is only available if there are comparable high standards measured, of course, by outcome. It means that it is only available if comparable standards are vigorously enforced. And as you know, in Europe, we are considerably strengthening on the enforcement side. We are introducing heavy sanctions. We are stepping up the supervision, the intensity of the supervision. We have new authorities, ESMA present here. So all that is exactly driven by that dynamic. Now, substituted compliance should also not be certainly not be a blank check. It must go hand in hand with intense cooperation between the regulators. So it is not acceptable that we would say, okay, now we have recognized equivalence of a third country jurisdiction, therefore we are no longer allowed to look at what happens in that jurisdiction. So there must be an intense flow of information. There must be the right of the other country regulator to get information, to be involved, etc. That's very important. Two, there must be, I would suggest, always a clawback power. Because if we give substituted compliance, if we give equivalence, if we give recognition to a third country regime, then it must mean that if that third country regime is not applying these rules correctly, that I find back my powers to apply them myself. And this is nothing new. This is what international committee principles have told us for a long, long time. You know this better than I do, but I remember when I practiced them in the field of competition, we knew perfectly well in active and passive committee issues that if the other jurisdiction would not do what we would ask them to do, then we would do it ourselves. So this is what I call the clawback position. So substituted compliance should not be equivalent to soft enforcement. It is a serious, but we need it here. We may not need it in other areas, but here, where the G20 has imposed mandatory clearing for a global market, which affects daily operations, margining, et cetera, if we don't have substituted compliance in this field, then I think this system is simply not workable. So that's what I want to say. If you allow, I would make a small tango with Patrick here that he can say a few words about why it is not workable for concrete reasons.
Commissioners, Chairman, this is a complex area. This is a global market. We agree with everything the SEC said that trying to regulate the cross-border rules verges almost on rocket science. We did that. We did the rocket science, and we produced for regulators an 80-page comparison between 342 pages of European rules and all of the relevant rules in Title VII and the CFTC requirements. We did a line-by-line rocket science comparison. And I can tell you this is a potential Apollo 13 situation. The message is, Washington, we have a problem. That's an objective fact. That's not fiction, it's a fact. And as one of your former secretaries of trade once said, I don't know where to start, but I do know where to end when I start trying to list the number of examples of potential problems that the current approaches raise. There are a lot of known knowns that we can already draw conclusions on today as to why proposed approaches across the globe simply won't work. They won't mesh, they won't interact, they will cause conflicts, they will cause inconsistencies, they will cause gaps, and in the end, the conclusion is many of the G20 requirements and expectations won't be met. Not because of lack of goodwill, but because we need to take a wider view of how our rules work on a cross-border basis in this global market. Now, I'll try and give you 4, 5, 6, 7 very simple examples. We have a whole list. We simply don't have enough time in the day to go through all these examples with you. A simple example is, what if we have different mandatory clearing determinations? Just one example. Is this possible? Yes. Is it probable? Yes. This is a possible probability. You have a different mandatory clearing requirement. We have firms from Europe that are registered in your jurisdiction. They fall under your registration requirement. What if the trade is subject to mandatory clearing in the United States of America, but it is not subject to mandatory clearing in the European Union? What happens if the DCO clearing the trade in the United States of America is not recognized under European rules? It is possible. If you look at the comparison between European and US rules on DCOs, there's only one inexorable conclusion. Europe has far tougher, far stricter safety, stability requirements for DCOs than the United States. But the United States has higher requirements as regards conduct of business rules. But what if we do not have that registration, we do not have that recognition of DCOs across the Atlantic? The trade can't be cleared. Or you require the same trade to clear in one country, in the United States, and we will subject exactly the same trade to bilateral initial and variation margins in Europe. The trade will not take place, full stop. The risk that countries and that firms run cannot be hedged. That's not good for our economy, it's not good for our firms. In the end, it's not good for jobs. You cannot hedge that risk. Another example, the same trade is actually subject to the mandatory clearing requirement in both our jurisdictions. What if the European DCOs are not authorized to clear that trade in the United States? You have the same conflict again. Or, even worse, you will have a requirement in Europe and in the United States to clear the same trade on two different DCOs. The conclusion is the trade will not take place. If we move from that example to a potential third example, what do you do for corporates, for non-financial firms? What if you have a swap dealer contract registered here with a swap dealer with an American non-financial corporate? Swap dealers European, the corporates American. It's not for hedging. It doesn't necessarily mean that this is a bad contract, but it's not for hedging. In Europe, if that contract falls below a clearing threshold, you do not have to clear that trade. But the same trade must be cleared in the United States of America. You can't conclude the contract. Which corporate would want to conclude a contract that is subject to mandatory clearing in the United States but is not subject to mandatory clearing in Europe? You can't hedge your risk. It's not good for the economy. It's not good for the firms. It's not good for jobs in the end. You cannot conclude that trade. But what if the same swap is for hedging? It's a hedged swap. But the swap is above the European clearing threshold. You have a conflict. You exempt in Europe that contract. You exempt in Europe that contract for clearing, but in Europe you have to clear that contract. Again, you have a conflict of rules and requirements. The trade will not take place. The swap will not be concluded. What if we have an affiliate of a US life assurer in Europe? They do still do business in Europe. They're still out there, Gary. Commissioner Gensler, sorry. You have an affiliate of a US life assurer in Europe. It has an interest rate swap with a European dealer. It's registered here in the United States. That swap doesn't have to be cleared in the European Union. It will have to be cleared as a financial in the United States of America. The contract will not take place. There will be no deal. And the US firm simply cannot hedge its risks. You have US life assurers who guarantee, who insure property, who insure lives, pensions in the United States of America, who insure investments. The trade will not take place. Reporting, we have a European and a US counterparty. Both have to report to a swap dealer repository. We did the rocket science, we compared the rules. The European rules are tougher, stricter, more granular as to what has to be reported. The details, the reporting formats, the timestamps, everything is there. The US rules are potentially stricter on when you report, the 30-day minimum that might even be reduced further. You have a problem because the same trade would potentially be reported to a swap dealer in different formats, different times. What if the swap data repository recognition doesn't take place? It is possible. We might not recognize each other's swap data repositories. You have the same trade reported to different swap data repositories in different formats. We can go on and on and on. We did the work, we did the rocket science, we've done the Apollo 13, and the message is there. Washington, we have a problem. Apollo 13 had a happy ending. It ended up with blue tack and sticky tape. That's not the ending we want here. We want a happy ending. The legal counsel for the CFTC told us that he watched Apollo 13 recently. It was on your public broadcasting system. And he actually suggested that the lesson we have to learn from Apollo 13 is the only way to solve this is cooperation. We know what the problem is. The problem is your registration requirements. It's the wide definition of US person. It's the narrow scope of substituted compliance. That's where, through cooperation, we believe we can resolve many of the issues, and many of the issues I've tried to explain here, and many issues I haven't even been able to bring to the table because we still have other jurisdictions to listen to. Thank you for your attention.
Thank you, Emil and Patrick. I'm now going to turn to a joint presentation from Singapore, Hong Kong, and Australia.
Firstly, thank you, Commissioners, for the opportunity to speak, and thank you to my colleagues around the table, and also a big thank you to the CFTC staff, who I know have been working day and night under trying circumstances. As you mentioned, we're going to do a joint presentation, the Australian, the Singaporean and the Hong Kong regulators, partly because I think we share some joint considerations, most of which I think it would be fair to say have been raised already around the table. The first thing I would say from an Australian perspective is that we do take our G20 commitments very, very seriously. That's a perspective that I bring to the table, but also one that my stakeholders were very eager to ensure that I shared at this meeting. Domestically, we have in place a framework for regulating swap dealers, or what you refer to as swap dealers. That's an arrangement that has been in place for quite some time. It's an extensive arrangement subject to significant regulatory oversight, not just by the securities regulator, but in circumstances where the swap dealer is a bank, and most of them will be for your purposes, they're prudentially regulated as well. So there's an extensive framework that goes on at the entity level in Australia. At a transaction level perspective, we have legislation moving through the Parliament, which will provide the government and the respective regulators with the power to mandate trade reporting, clearing, and trading on a platform. We have a licensing arrangements in place for clearing facilities, both domestic and foreign, looking to do business in our jurisdiction. We have licensing arrangements in place for trading platforms, both domestically and foreign, that are looking to do business on our platform. And this additional regulation will not only provide us with a mandate to ensure that that occurs, but will also provide us with the opportunity to deal with that as the issue arises. More specifically, we have just completed a market oversight assessment report, which has been published. The purpose of that assessment report was to be very, very clear about the nature of the Australian OTC market. It made some anticipatory recommendations in expectation of the legislation being finalised and being put through Parliament. The expectation is that there will be a broad mandate on trade reporting. The expectation at this point is that for Australian dollar denominated interest rate derivatives, we would expect, and we've been cleared to industry, that we would expect them to be centrally cleared in the coming period. In the absence of an industry move or industry meeting those expectations, we will have the power to mandate that. In terms of trading on platforms, we will also have the power to mandate. We'll continue consideration of whether it is appropriate in our circumstances, which we anticipate may well be the case again in the coming period, and we'll review the domestic nature of our markets in the middle of next year. That gives you a reasonable overview of where we've got to from an Australian domestic perspective. I'll now turn to my Hong Kong colleagues who can give you their own.
Thank you, Oliver. I'll briefly go over the status of Hong Kong's effort in carrying out the OTC derivatives market reform. In October 2011, we issued a consultation paper to consult the public on our thinking about the general framework of our proposed regulatory regime for the OTC derivatives market in Hong Kong. We completed that exercise in July this year. We issued our consultation conclusions. At the same time, we launched a supplemental consultation on the proposed scope of the new or expanded regulated activities and of the regulatory oversight proposals of systemically important player. We are finalizing our consultation conclusions paper, and we aim to publish that before the end of this year. To implement the reform, we need to amend our Securities and Futures Ordinance. The amendment will comprise of two parts. The first part will be the change of the primary legislation. The second part will be the introduction of the subsidiary legislation, which sets out the detailed rules to give effect of the provisions in the primary legislation. It is our target to introduce the amendment to the primary legislation to our Legislative Council in early 2013. At the same time, we aim to consult on the detailed subsidiary legislation at around the same time. Subject to the passage of the relevant legislation by our Legislative Council, we target to implement the new regulatory regime at around third quarter 2013. In terms of the cross-border application of our OTC derivatives rules, although the primary objectives of our legislative amendment is to regulate the OTC derivatives activities conducted by Hong Kong regulated entities and other Hong Kong persons. But because of the cross-border nature of OTC derivatives transactions, the Hong Kong rules may apply to a transaction between a Hong Kong counterparty and a non-Hong Kong counterparty. The Hong Kong rules may also apply to a transaction between non-Hong Kong counterparties on a very limited circumstances, whereby one example is that an overseas subsidiaries of a Hong Kong bank, if the overseas subsidiaries of this Hong Kong bank is designated by the Hong Kong monetary authorities under its consolidated supervision regime for ND avoidance purposes. For overseas financial market infrastructure providing services in Hong Kong under our OTC regime, third country trading venues may provide services in Hong Kong if they are approved by the SFC as an authorized automated trading services provider. Third country CCP may also provide services to meet the Hong Kong mandatory clearing requirements if approved by the SFC as an authorized automated trading services provider. Although the name of our regime is called Automated Trading Services ATS regime, but its scope actually include the CCP's offering service in Hong Kong. Overseas ATS are regulated under a light touch approach under our ATS regime. We place heavy reliance on a day-to-day supervision by its home regulator. On the mandatory reporting obligation, our current thinking is that it must be fulfilled by reporting to a TR to be operated by a Hong Kong Monetary Authority. But the TR operated by Hong Kong Monetary Authority will accept reporting via global TRs or confirmation platforms to facilitate the reporting by global swap dealers and also to mitigate the burden of the reporting requirements. For derivatives market intermediaries, overseas intermediaries are required to be licensed in Hong Kong only if they actively market their services to Hong Kong. And generally, we expect overseas licensed corporations or licensed corporations are normally required to be locally incorporated. Now I will turn over to my Singapore colleagues.
Thank you. Thank you, Commissioner, Chairman, and members of the Global Markets Advisory Committee. We welcome the opportunity to come here and share our views on our cross-border implementation concerns. Singapore, of course, is committed to implementing the G20 reforms. We have been making progress on this over the course of the past few years. Just a quick update, we issued a policy consultation in February on the implementation of G20 concerns. In particular, we consulted on mandating the central clearing and reporting of OTC derivatives transactions. We also consulted on extending to OTC derivatives our current regulatory regime for clearing facilities and for market operators and for market intermediaries as well. We also consulted on introducing a new regime for trade repositories. In developing our approach to these reforms, MAS has reviewed the state of the derivatives markets in Singapore and also took into account industry feedback, which led to further consultations issued in the past few months. In May this year, we issued a supplementary consultation with proposed legislative amendments to our existing regime for clearing facilities and to introduce the new regime for trade repositories. The consultation sets out the licensing approach as well as the general obligations which a regulated trade repository or a regulated clearing facility will be subject to. In August, we issued a separate consultation with proposed legislative amendments setting out the mandatory clearing and the mandatory reporting obligations. We then consolidated these supplementary consultations into a set of draft laws, as keeping in mind the broad-ranging amendments which we'll have to put in place to implement the G20 reforms. We are undertaking these exercises in parts. The first phase implements the mandatory clearing and reporting requirements, as well as the supplementary regulatory frameworks for OTC derivatives clearing facilities and trade repositories. These amendments have been introduced in our Parliament in October this year and are targeted to be passed into law by the end of this year. In relation to this set of laws, we will issue further consultations on the detailed rules to implement the regulation of these OTC clearing facilities, trade repositories, and again on the mandatory clearing and reporting obligations. These will be consulted upon in the coming months. In relation to other aspects of OTC reform, in particular the regulation of OTC derivatives market platforms, market intermediaries, these are being considered and we will also consult on them at a later stage in 2013. Just a brief note on where our cross-border implementation overlaps may lie. In some instances, Singapore clearing and reporting obligations will apply to transactions between a Singapore counterparty and a non-Singapore counterparty. Generally, the mandatory clearing and reporting obligations will be applicable as long as there is a Singapore counterparty to the transaction, including in cases where the opposite counterparty is a non-Singapore counterparty. Singapore rules will also apply where non-Singapore counterparties transact with an overseas subsidiary of a Singapore incorporated bank. So where entities are subject to mandatory clearing and reporting obligations, counterparties must fulfill their obligations by clearing or reporting through a clearing facility or a trade repository that is regulated by the MAS. Where overseas incorporated clearing facilities and trade repositories come in, they are able to seek licensing from MAS under a recognition approach. So under this approach, we assess whether the overseas entity is subject to regulation and supervision, which is comparable to our Singapore regime in terms of achieving our objectives of regulation. We also assess whether adequate arrangements exist for cooperation between MAS and the home regulator. Under this recognition approach, we are then able to license the overseas entity based on our broad reliance on the home regulator for the regulation of the overseas entity. So essentially, we have put together the foundations for linking up and perhaps smoothing the jagged edges where our regime meets the international reaches of our foreign regulatory regimes. Certainly, the interaction of our regimes with other jurisdictions may still give rise to cross-border implementation issues. Industry has raised some concerns, and we have also, together with Hong Kong and Australia, mentioned our concerns to the CFTC. My colleague Kenneth will move on.
Thanks, Ken. Before we cover our concerns on cross-border issues, we would also like to recognize the efforts of our CFTC and SEC colleagues that are already being made towards addressing these cross-border issues. So our primary concerns on cross-border issues are twofold and are broadly similar to those raised by our colleagues in Europe and Japan. First, we note that entities outside the US may be subject to the requirements of multiple jurisdictions. This creates the potential for overlapping or even conflicting requirements. Second, uncertainty remains over the meanings of key terms in the proposed cross-border guidance. This combination of uncertainty and overlapping requirements can increase compliance costs for industry and could lead to unintended consequences, such as increased market fragmentation or even increased systemic risk. To shed more light on our concerns, we will now elaborate on 6 issues we have identified in the CFTC's proposed guidance. First, in respect of the definition of US persons, we note that at present, practical difficulties remain for market participants in determining whether a counterparty is a US person, and uncertainty also remains over the potential scope of the US person definition. Second, in respect of substituted compliance assessment, we support an outcomes-based approach to this assessment that focuses on expected regulatory outcomes and takes applicable global standards into account. We also call for appropriate transitional arrangements in this regard. Now my colleague from Hong Kong will bring us through the next 2 issues.
Thank you, Kenneth. The third issue that I want to talk about is on client confidentiality. We all agree that trade reporting is an important tool to collect information for further analysis. However, there is a potential problem when the counterparty whose information is being reported is situated outside the jurisdiction that requires the reporting. The ability to comply with the US reporting requirement may be hampered by conflicts in local laws. Normally, a client agreement will have taken care of situation where the reporting is required by local laws or regulations. But there is an additional concern when both counterparties to the transaction are situated outside the jurisdiction that require reporting. Like, for example, in a situation where the dealer is an Asian subsidiary of a U.S. bank or is a non-U.S. swap dealer situated in Asia. And because this is outside the normal home host arrangement and it's actually a third-party regulator that require the disclosure, the client agreement would not have taken care of it. And on top of that, there may be local privacy law or bank secrecy law that prevent this type of disclosure. In some extreme situation, this is the case even though the dealer may have obtained client consent. And sometimes it can be a criminal offense for the dealer to disclose the information. ISTA in August 2012 has published the new Dodd-Frank protocol that will help to address some of the issue. But in order for the client to sign up to the protocol, the dealer needs to spend time to educate the client, and this is a time-consuming process. Especially in some of the smaller jurisdictions, the client may not be very familiar with the Dodd-Frank requirement. And if, say, they're doing a local currency interest rate swap, they're not dealing with a U.S. person, they're not U.S. person, it will be difficult for them to understand why their transaction is subject to reporting to the U.S. regulators. And on top of that, in some situation, the dealer may need to get the consent from the local regulators for the trade to be reported. And in some situation, some jurisdiction may have to amend their law in order to grant this type of disclosure. We understand that there will be some transitional arrangement to take care of this situation. However, we would like to stress that we should not underestimate the extent of the issue and the time required to resolve this issue so that there will be adequate time for people to address this particular problem. And the next issues is on U.S. affiliation. In the phase compliance proposal, which was published in July, it proposed that there will be some temporary exemptive relief for non-U.S. swap dealers and non-U.S. major swap participants. They can delay compliance with certain entity level and transaction level requirements. One example is the reporting requirement for swap with non-U.S. counterparties. And however, there's actually a condition attached to it. And for any non-U.S. person who is affiliated or subsidiaries of a U.S. swap dealer, they will not be able to enjoy this type of exemption. But we wish to point out that there are situations where the U.S. person and the non-U.S. person, they operate totally independent of each other. The non-U.S. swap dealer is not under the U.S. swap dealer's majority control. They don't receive any guarantee from the U.S. swap dealer. They are affiliated purely because they have a common parent, and the parent is actually situated outside of the U.S. So what we want to mention is for this type of swap between a non-U.S. Swap dealer who is affiliated with a U.S. swap dealer with other non-U.S. counterparties, they are unlikely to have any significant systemic impact to the U.S. And those non-U.S. swap dealers also need time to prepare for compliance. So we would like to suggest either removing or modifying this definition of affiliation so that the situation we mentioned early on will not happen.
Could I just ask a real quick technical question on that? Are you referencing when the parent, in that circumstance, the ultimate parent is non-U.S.?
Yes.
Okay, thank you.
Thank you. I have just two final issues, and they've been made previously around the table, so I won't labour them. But I guess the first is just the timing of the implementation and our strong support for any flexibility that is available, any additional flexibility that is available to take account of the fact that countries are moving at slightly different speeds, notwithstanding the strong commitment to meeting the obligations. The final one is just around registration of a domestic CCP as a DCO, the mechanics around that and the capacity for that to swiftly happen if in fact the need arises. Thank you.
Thank you all so much. And now finally we'll turn to Quebec for their presentation.
Thank you very much, Chairman Summers and the CFTC for the opportunity. We'd like to also voice our appreciation to the CFTC for holding this and other meetings. The level of inclusion and cooperation in this process is really impressive and unprecedented, and we do sincerely appreciate it. Just yesterday, the FSB issued a statement urging regulators to pursue further discussions before the end of 2012. And as Chairman Gensler rightly pointed out, there's not a lot of 2012 left. So the timing of these meetings is very important. I'm in the fortunate position of following all of my international colleagues who have spoken much more eloquently than I could on several of these issues. So I'll try and focus on specific Canadian issues and maybe reiterate some of the burning points, but I won't get into as much detail. Canada has very close economic ties with both the U.S. and the EU. The majority of our OTC derivatives contracts between our financial institutions are with foreign counterparties. And not surprisingly, the majority of those are with U.S. counterparties. So our market participants are going to have to comply very quickly with foreign regulations, with U.S. rules in particular. And this could cause some serious conflicts, both in the short term where there is a gap, but also in the long term as we go through the substituted compliance evaluation process. The CSA, which is the umbrella group for the various provincial securities commissions, the Canadian Securities Administrators, has been working diligently to meet the G20 commitment objectives. I should explain that in Canada, our securities laws tend to be very highly harmonized across the country. The legislation all looks very familiar, and we tend to issue rules as a national instrument that each jurisdiction would sign on to. The derivatives markets are not nearly as harmonized, far from it. We have different regimes. In Quebec, we have a dedicated legislation, the Quebec Derivatives Act. Ontario has, for listed derivatives, the Commodity Futures Act, but OTC derivatives are treated under their Securities Act. That's the same in Manitoba. In other provinces, particularly BC, Alberta, Saskatchewan, and New Brunswick, they have blanket orders that deal with derivatives markets. So we can't come up with national harmonized rules, but what we are trying to do is come up with model rules that we will then adapt. So we will go out with a consultation process in our rulemaking. So the marketplace will see that even though the end rule might look a little different from jurisdiction to jurisdiction, the regulatory objectives and how we get there will be the same. So in Ontario and Quebec and Manitoba, we have modified our legislation to ensure that the G20 commitments can be put into place through rulemaking. And then on a national basis, other jurisdictions are working on legislative amendments. And the rulemaking is going through a consultation process. We, 2 years ago, published an overarching policy document, and then we followed that up. We have 8 consultation documents, 5 of which have been published on various subjects: trade repositories, clearing, segregation and portability, enforcement, and so on. We are going to be publishing, hopefully this year or in January, our trade repository rules. Those will be followed by clearing rules. So we're trying to prioritize them and what we think needs to be done the most quickly to make sure that we can meet the G20 commitments. We are, of course, reviewing U.S. rules and European rules and other rules as we go through this. We have the benefit, just as I have the benefit of following my colleagues around the table today, you do have the benefit when you're drafting rules after they've already been implemented in other jurisdictions of doing a comparison, doing analysis, trying not to use the photocopy as your main legislative tool, but actually do some, as we propose rules to our chairs, to use some analysis, do some thought to it, and make sure that we're coming up with the best solutions. So we feel that it's important that the larger jurisdictions already have the rules in place. They recognize that the timelines, and it's been mentioned quite a few times around the table, the timelines are very constraining. And they do create some interim and probably temporary but very important issues. A question, for example, that was brought up was regarding the reporting to a trade repository. Until we have RTR reporting rules in place, we aren't protecting the people reporting from any privacy issues. That rulemaking needs to be in place to give them the legal certainty that reporting is not violating any privacy issues. So that is a gap that will be
dealt with rather quickly, but in the interim, it is a very significant concern. I can skip over a lot of this because my colleagues have been so good. To speak about substitute compliance, I think equivalence or substitute compliance is an excellent solution, although it's difficult for us to assess how it will be, how effective it will be, or how it will be carried out until we have more details. If substitute compliance is going to be done on a rule-by-rule, line-by-line basis, I don't think anybody could ever be determined to be equivalent. Whereas if it's done on a more holistic basis, I think we all have the G20 goals in mind, and I think that we could all make a good argument for achieving equivalence. There's also the assessment should also take into consideration that international initiatives, some of them are still underway. Particularly when you think about the BCBS IOSCO working group on margin requirements that we're all committed to implement generally. That work is very important for all of us as we go forward. We are working on adopting the PFMIs as the rules for clearinghouse, and we will, as everybody else, be PFMI compliant. We're concerned, however, in the implementation that internationally, in terms of communication and cooperation, perhaps in the time of a crisis at a CCP, that the home regulator and the various regulators in other jurisdictions who have licensed that CCP, that information and flow and cooperation in a crisis situation needs to be ensured. And we think that it can be, but a lot of work needs to go into managing a crisis. It's our role, of course, to try and avoid ever having a crisis in a CCP, but we do need to plan for it. Another point worth mentioning, in Canada, we are not currently contemplating developing a trading mandate for electronic trading until we've had time to look at TR data. So once we get more TR analysis, understand more the liquidity of our markets, the effect of a trading mandate, what it could have. So we are providing ourselves with the regulatory powers to mandate trading, but we're not going to implement that, or we're proposing not to implement that until we've had some time to better understand the marketplace. The other concern that's been brought up around the table is the concern about the conflicts that would be created if a derivative is mandated for clearing in one jurisdiction, not another. I don't need to belabor that point. So I think in summary I can say that although the end of 2012 is clearly we will not be have the rules in place to meet the G20 commitments. I think a lot of the G20 commitments will be met as our infrastructure has to respect Dodd-Frank anyway. The reporting will happen. The clearing is already happening. The rules will be in place over the course of the next year. We do feel the progress that we've made, the momentum behind our regulatory development is going a long way to put the objectives of the G20 leaders into an effective and robust regulatory regime, and we look forward to ongoing cooperation. So thank you.
Thank you, Derek. I think certainly what I've taken from all the presentations this morning and am encouraged by is every jurisdiction that is sitting around the table today's commitment to all of our obligations to the G20 commitments. And although these issues are enormously challenging and we have a lot of different concerns around the table, but we all have the commitment to resolve any conflicts that exist. I am going to, I have a quick question. I'm going to turn to my colleagues for any questions they may have, and then we'll turn to the GMAC members who are sitting at the tables at the sides if they have any questions with regard to the progress of any of the jurisdictions that are around the table today. So I guess my question would be for anyone who has made a presentation today with regard to the progress and the opportunity that you've had over the past 2 days to speak with each other about some of these very complicated and challenging issues. Where do we go from here, and what is the next steps for all of us to make sure that we have coordinated efforts moving forward so that we can protect these critical markets. Is there anyone who wants to? Emil, thank you.
Yeah, I think we have a mandate from the FSB to put to the principals the identification of inconsistencies, conflicts, gaps. So the first mandate which the FSB asks us to do is to identify where the problems lie. And then I think the next logical step is that our principals discuss openly in a cooperative spirit and a constructive spirit, which certainly they will do, what are the options to overcome these inconsistencies, these conflicts, these gaps, without hurting anybody in terms of effectiveness and without unduly loading companies which are subject to monetary clearing. So that is the next step, I think, to first to identify and then to look at the options. And hopefully we would think that on the basis of that agenda, that the principals could come out with a consensus view of how one should deal in this global market between jurisdictions with cross-border issues, which we all have. And I think that is feasible. I think that can be done, you see. What I would like to add to that is that there are two categories of issues. There's a category of issue of conflicts, inconsistencies, and overlaps. I think that block of issues can be dealt with by substituted compliance, by equivalence, by recognition in an efficient way. There's another set of issues, which are the gaps. A number of them were mentioned by my colleague, Patrick Pearson. The gaps relate to issues of scope. And we think that that is a different piece of cake, much more serious piece of cake. We think that in relation to gaps, there's a need not only to work on substituted compliance and the definition of what is a US or EU or Hong Kong or Singapore person for the application of our cross-border rules. I think it is necessary to go back and look at the convergence of the rules and the ratio behind these exemptions, whatever it is, these differences in scope of application between our jurisdictions. Because we fear that if there are too many of these exemptions and gaps between the jurisdictions, we get an accumulation of non-regulated spots. And if on top of that, it is combined with cross-border issues between jurisdictions, then we don't know where that is going to end. This can lead to migration of transactions. This can lead to regulatory arbitrage, all things which we don't like, which we don't want to see. Now, it is not the gap block of issues, the scope block of issues, is not so much, it can't be resolved with substitute compliance or equivalence or recognition. It's not a matter which we can resolve in the short term. It is a more long-term issue, but it has to be done. And therefore, for me, that is the third a step in the further work to be done, is we need to see what we can do about that. What we can do. We need to first identify, is it material? Is it going to disturb the system? Or can we live with it? Status quo or not? If not, should we not then make another attempt to analyze what are the reasons for these exemptions and see whether we cannot further converge? Because, of course, the best and the fundament of every cooperation is convergence on the rules of substance. And once you have that convergence on the rule of substance, which is the work of the G20, where we have done 80, 90%, I don't know how the correct percentage lies, but it is a high percentage of convergence which we have already achieved. Once you have done that, we all know, as Gary said, the devil lies in the detail when it comes to the interpretation of this and that word, when it comes to the application, even with that. Suppose even we had harmonized rules. David Wright, Secretary General of the IOSCO, said recently in the newspapers, in the FT, that we should go for harmonized rules. Now that would be the ideal world. I think that is a dream that may be reachable in 20 years' time. But we don't have but even if we had harmonized rules, we know inside the European Union where we have harmonized rules that that is not the end of the game. You need still to have then guarantee of a harmonized application of the rules. And therefore, we will not, this is not reachable by any other means than substituted compliance combined with intense cooperation between the regulators, intense information exchange, and, as I said, clawback powers, so that you have the discipline in the system. That is one thing. So we can solve a lot of things via that process of substituted compliance. But there are things, we should be aware of that. There are things which we cannot resolve with substituted compliance. And we need also to look at that package of issues. So I would say I'm optimistic, you see. And to quote somebody who was elected president of this country last night, the best is still ahead of us, you see. So I think we can achieve that. We are close to the goal, but we should now walk this last mile really together, only because it is necessary, but also I think I can detect that it is feasible and that we have the spirit of doing it.
Thank you, Emil. Masa.
Thank you very much. While I don't disagree with Emil on the points he has mentioned, I think we do need some solutions in the very near term on very pragmatic issues. And in fact, on page 9 and onwards in my slides, we have actually raised some very specific points. And this is quite important to businesses because, well, of course, we can talk a lot about the ideal state of the world. We can also talk about what in the longer term we should achieve collectively, one set of rules that are commonly applied, no overlap, etc. But businesses have been used to overlaps or minor or mild inconsistencies in rules for decades, and that has not really prevented global capital or markets from being global. And so in that sense, we would certainly like the particularly conflicting parts of our rules or the most contentious issues in the near term to be addressed sooner than later. And then, of course, have a vision for the longer term. I mean, I can call this perhaps a two-stage approach, but we do need some urgency on resolving those very short-term issues quite quickly. Thank you.
Does anyone else have anything to add to our next steps? I'm going to now turn to my colleagues. Chairman Gensler, do you have any questions?
If it's all right, Commissioner Summers, I might just respond to your question a little bit, and then some just reaction, because I think this was a very helpful and beneficial discussion. And I recognize, and I've spent so much time with really just about each of your jurisdictions and each of you personally at international meetings, so I like having you here as well, but I look forward to seeing you in Europe and in Asia and in Canada again. I think that I find myself agreeing with both Emil and Masa's answers to Commissioner Summers. There's some urgent matters that we need to address, and that's why Carlene and many other colleagues and the staff have put something back in front of commissioners. It will continue to change. Today's meetings will help us, focus on those important details. It's why I asked, I apologize, I can't remember your, but I don't want to mispronounce, Daphne, technical, because these technical issues are really important. But I'm hopeful that we can move forward and take all the very good comments about the definition of U.S. person and try to tighten that up. All the very important and critical comments that we've heard today. I agree with Emil, though, that there will be some, as you say, gaps. We have different political systems. We have different cultures. We had different histories living through the crisis that sort of animate us. So we might have embedded in statute something you don't. And one of those things we have embedded in Dodd-Frank is a registration regime for swap dealers. And that is one, frankly, that we're grappling with here. That Patrick, one could read what you suggested is maybe not have the registration happen come January. I don't think that's what our statute says, but that's one thing we're grappling with, that we do have this registration regime. But we have a long history at the CFTC of mutual recognition, of substituted compliance, of memorandums of understanding, and we embrace them and wish to embrace them through this challenging time of registration with substituted compliance. But I think that's one difference that's embedded in our statute, frankly. I think partly the reason it is, if I can say, is background. We've all lived the 08 crisis, but when $180 billion of U.S. taxpayer money went into a company called AIG, an insurance company, AIG Financial Products, incorporated in the U.S., actually had its banking license from France and operated in Mayfair. And the primary risk-taking operations was a Mayfair branch of a Paris bank, though the legal entity was somehow a U.S. legal entity. And $180 billion of U.S. taxpayer money went into it, but more than that, it almost toppled our whole economy, and 8 million Americans are still out of work who might have otherwise been working if we didn't have this crisis. Long ago, Long-Term Capital Management, a hedge fund operated out of Connecticut, actually booked its $1.2 trillion notional derivatives book in its Cayman Islands legal affiliate. We all thought of it in Connecticut, but it was booking it in a legal entity in the Cayman Islands. The reality of modern finance is many large financial institutions and small ones set up legal entities as structuring vehicles to maximize their ability to serve their clients, but also to take opportunities on funding, on taxes, on regulatory matters, in a very constructive way to run their business. Sometimes also to do regulatory arbitrage, as Emil said, but often it's for constructive reasons. The largest financial institutions here in the U.S. often have 2,000, 3,000 legal entities, literally. So the question in international finance today is, what happens when one of those fails? Can it be separated off? Is there a true subsidiarization? Can something be hived off? I think experience tells us the answer is not really. When there's a run on one part of a financial institution's global network, there's usually a run on the whole network. And why is that? Because it's logical. Who is really going to lend to the parent that's guaranteeing some offshore affiliate when they don't know what's in that offshore affiliate. And as good as the SEC's disclosure regime is, and it's excellent, but as good as it is, when you're dealing in a crisis, there's never enough information. There's always an asymmetry, there's uncertainty, there's a run on something in the Cayman Islands or somewhere, there's a run on the whole. That's what happened in Lehman Brothers, it's what happened in Bear Stearns, it's what happened almost to Citicorp, but the US government put not one, but 2 rounds of finances into there. There's special purpose vehicles called SIVs, the CIVs. They were all incorporated in the Caymans as well, originally set up in Europe, but they were incorporated in the Caymans. So we have that reality of modern finance, and Dodd-Frank addressed that. And so we have a lot of US institutions that we don't think, and I'm talking about the US ones now, US parents, I was trying to get Daphne's point, that we don't feel that we can just say, you know what, if they have a guaranteed affiliate sitting in Europe or Asia, that's a subsidiary and the bankruptcy code will protect the US taxpayers, because it really doesn't. You know, when it's a guaranteed affiliate, all that risk is coming back here. If it's a branch, we all know that a branch is the same part as the legal entity. Now, so that's what animates us. And then the registration regime. So the non-US entities, the many really large, significant interest from Europe and Asia and Australia that do business with US persons. So we'll tighten the US person definition, and we have this de minimis of 8 billion, and we're taking very seriously the comments on how that should apply, and should it apply to all of your affiliates or just some of them, maybe the largest, this topic we call aggregation. And I think we've taken that up, and commissioners will try to narrow that as well. But if you're dealing enough with US persons in a narrower definition, that then Dodd-Frank applies, because that's what our Congress has said. Now, we might be able to do, as Emil says, this substituted compliance, and we look for a lot of good dialogues with that. And we've done that so actively in Europe and in Asia. I'm not sure if we've done as much in Australia on that yet. And we look forward to doing that a lot more. So I just wanted to mention those thoughts on central clearing. We have no geographic mandate. We're fine with clearing houses we like LCH, ICE Clear Europe. The bulk of energy business, interest rate business, credit default swap business actually clears offshore. And we haven't, I mean, that's probably will be enhanced, and there'll be other jurisdictions, including Japan and elsewhere. I know we have to sort through, and Mas has raised very good questions that Ananda and others are trying to sort through. And I'm committed to try to help get that sorted through. So I just, Patrick, I think the problem that we have is that the financial system failed all of our publics. And so we're all grappling together to try to, enhance the transparency and oversight, and recognizing that risk can flow back to our shores so rapidly in a crisis. So,
Commissioner O'Malley, do you have any questions for the group?
I do. To that point about risk flowing back to our shores, I appreciate that it can and does, but I want to understand a little bit more about that test. Emil, you raised the point about direct and significant. What is the test? I think we failed that test in our cross-border guidance. And I would point out that great opportunity. I think the SEC has taken the right approach to do a rulemaking on this, and I would prefer that we would do a rulemaking as well. But to the direct and significant test, everybody around the table has talked about clearing as a risk mitigant, and I agree with that. And we have to work that out. And to the chairman's point, we do rely on foreign clearing houses, and hopefully with Japan joining as well. But when it comes to the transaction rules, what is the direct and significant test if we've already cleared a product? And I'm interested to know a little bit more about what the EU is thinking about solving that transaction level requirements in light of the direct and significant. And Carlene, by all means, if you've got some thoughts on this, on how we can justify beyond, some of these transaction rules in isolation. And, we say that all of our rules apply as part of the direct and significant test. What is the test, first of all? Is there a comparable test in Europe and Asia? Any of the Asian regulators want to comment on this? I'd love to have it in Canada as well. And then what if the difference is over the transaction rules, how do we solve that, and how do we mandate, how does our statute allow us to mandate at the transaction level? So maybe Patrick, if you could, or Emil, I'd be interested in your thoughts on this.
Thank you. Very, very good points. We faced exactly the same conundrum as you did over here. Risk flowed back to your shores, but risks also flowed across the Atlantic into the shores of the European Union, not only the continent, but also that little island called the United Kingdom. Chairman Gensler, these are the realities. So we asked ourselves exactly the same questions as you did, and we went through the permutations. Option one, we ring-fence our firms. No risk, you've ring-fenced and isolated all of the risk. Doesn't work. International trade, international firms don't work like that. Secondly, when American Express Bank went down the drain at the beginning of the 90s, the market responded. It said membership has its privileges, ownership has its requirements. The market expects the parent to stand behind the subsidiary or the affiliate. The way you chose to go is to extend the requirements and the rules to the affiliates and the branches outside of the United States. We have chosen a different way. We have also needed, and we were required to understand and accept that regulators in Europe simply cannot apply all of their rules to the more than 3,642 entities that operate outside of the European Union. It's physically impossible. We don't have the staff, we don't have the wherewithal, we simply cannot do it. It is difficult enough in Europe setting up a banking union for 6,422 banks within our own shores, but supervising the activities of our firms outside of the European Union and making sure that they apply and are subject to our rules simply can't work. And we accept the point about AIG. We accept the point that AIG went down the drain because of reuse of securities and securities lending through its Mayfair operation. Securities lending, not swaps, securities lending. When AIG lent securities to clients and the clients gave AIG cash to fund its activities, the ratings downgrade of AIG, and the client said, here are your securities back, AIG, now give me my cash. And AIG went down the drain because it couldn't cough up the cash within 36 hours. We accept that point. The only way we believe we can resolve this is through a maximum scope of deference, a maximum scope of substituted compliance to rules that we know protect the safety, have the same objective of our operations outside of the European Union. How do we do this? I'll ask Emil to explain that. He is much more versed as a lawyer to explain the process. But there is something else. What is the scope of a direct and significant impact on the European Union? Commissioner O'Malley, we don't know yet because we haven't made that determination. We can only make that determination after we've understood how other jurisdictions believe that they need to apply that scope. So is that interaction between the two? But Emil, would you like to explain the provision?
Can I just say, Patrick, I think, and we've worked so well together, I've just missed this quotes to Shakespeare, by the way, though.
I quoted Kissinger.
Yeah. Which was it that you quoted?
It was Henry Kissinger.
Henry Kissinger rather than Shakespeare.
Rumsfeld. There's a Rumsfeld quote in there.
And a Rumsfeld quote.
Yeah, Rumsfeld was the known. Kissinger was I don't know where to start, but I do know where to end.
But on the substituted compliance, I think I can't speak for my fellow commissioners, but I can just speak my own thinking. I think that we are going to rely on it. We, like you, we're a relatively small agency. We don't send anybody in to examine the U.S. futures business on a regular way. We're not the controller of the currency with 65 staff sitting in London at some bank. We don't have them sitting at the Chicago Mercantile Exchange. Hi, Brian. So we very much rely and look forward to relying on foreign regulatory regimes. I think on some of the biggest pieces of global derivatives reform, capital requirements, margin requirements, central clearing, we have really moved nearly in lockstep. I know we have a small bank exemption and you have a pension exemption. I mean, there are some differences, but it's remarkable how close we are to getting a unified approach to margin, which we here in the U.S. Have worked so closely with ESMA and the European Commission and our banking colleagues and so forth. And then through this IOSCO process, the MASA and then Basel Committee. I would hope that the margin requirements, whether it's the first quarter of 2013 or second quarter, that we'd come to some international consensus, real tactical consensus. Capital is, of course, with Basel. The clearing requirement is quite close. We then get to these transparency initiatives and data reporting. Data reporting into DTCC, by the way, is registered here. They'll be, I would assume, will be registered with you all. So I don't see that there's going to be an issue there. And there'll be other data repositories. CME has something in front of us. ICE, others. LCH sits in your shores for clearing, and ICE and others. So I actually think that we're very far along. And the substitute compliance, the challenges will come on timing on the public transparency because MiFID is yet to have happened. And so we have to sort through that. But so I'm more optimistic maybe than my colleagues from
Mr.
Europe.
Chairman. Back to my question.
Can I complete what Patrick said? First of all, it's correct that we have not yet implemented our test of direct and significant effect. It's a different language, but it's to the same effect, basically. We will certainly struggle with the same issues, but the approach will be different because we will want to link what we are going to do, to link it with equivalence. In other words, where there is equivalence, there's no need to apply the direct and significant effect test. We will link the two. While what you have done, you have defined in the absolute first what is direct and significant. You say, as a result, our law is applicable, and then all the rest comes. That's to say that all the provisions, all the requirements, as it is repeated several times, all the requirements of US law become applicable. Now, that is a very different approach. And it is material because when we discuss, Gary, these issues, we are very close to each other in terms of what you want to do and what we want to do. But I'm glad that Commissioner O'Melia raised the legal question of the test because your approach does not eliminate the application of more than one rule. It leads to the application of several laws. Well, our test of significant direct will lead to the result of application of one rule only in situation and in relation to those those territories, those jurisdictions where we find equivalence. So we link the two, and then we have only something. Now, this is hugely important because it has an impact, I think, also on what you said, Gary, at the beginning about, you said, we are compelled by our statute to require registration. Now, we would say that, of course, it's not our role to interpret your statute. So forgive me, I'm not going to do that. But I would say that Dodd-Frank Act probably has also some room to say that if there's a foreign jurisdiction and that foreign jurisdiction has all the requirements which are in our law, in the US law, then for that jurisdiction, we don't need to require registration of foreign resident established dealers, swap dealers. Why? Because simply these swap dealers, they are fully covered. There is no safety risk. They are fully covered. We can therefore rely fully on that foreign law. And when you make the weighing up of the interest under the international comity principle, where you have to weigh up the interests of the two jurisdictions, then I would submit and I would argue that where you deal with a jurisdiction where all these requirements are given, where the firms are already, where the swap dealers are already under obligation of registration, then the weighing of the interests of the two jurisdictions should lead to the result that you say, in that case, we don't require registration because it is a heavy interference because you impose an additional burden which is not necessary. And then the weighing on the international comity principle should normally lead you to the result. In that case, Dodd-Frank does not require us to impose registration. However, I can see two situations. If it is in relation to a jurisdiction where it is not sufficiently regulated, not comparable, not comprehensive, in that case, makes eminent sense that you say, sorry, we have by law to apply our registration requirement. So that I could see. You could also say, even in relation to a jurisdiction which has comparable standards, I do not now require registration, but if in the course of the cooperation which we will have with that foreign regulator, it turns out that a particular major swap dealer above 8 billion is not being supervised as it should, or there's a real material significance which occurs, in that case, clawback, you have to register. You come under my jurisdiction. But it would be more proportionate if you link these two issues and you made them apply in that particular circumstances rather than wholesale. What I want to point towards, you argue in the guidance, you say, we need to take an aggregate approach. We need to look at the whole business, and because the risk can come from the whole business, we can't just separate the transactions. We can't apply the test of direct and significant to each transaction individually. I appreciate, you see, I appreciate. But you can link it to the distinction between a jurisdiction which is comparable and comprehensive in its requirements as opposed to a non-comparable and non-comprehensive regulation. That you can do. That is feasible. And that would, I think, be, in my view as a lawyer, a more proportionate application of the international comity principle than the one which you... Of course, we can all say it is so nice if we can regulate more, because then we are absolutely sure. By the way, I mean, you mentioned AIG, you mentioned 180 billion, you see, but it could have happened to us what has happened to you. The subprime crisis started here, and we got the whole result, and then we aggravated that by many other crises, you see. So we are all in the same boat, you see. But as I said yesterday or the day before in another meeting here, you see, be aware that even in the smallest jurisdiction, if something goes wrong, don't limit yourself just to regulate your own business, you see, and that you say, I don't care what happens elsewhere, because what happens elsewhere may hit you tomorrow. So we share that.
Can I just add one point of clarification, and I hope this answers partly the transparency question, the transaction level reporting requirement question that you're asking, Commissioner Amalia, and that is the swap dealer, the new swap dealer and MSP regulatory regime is a comprehensive one. It's not just about prudential oversight. It's also about providing greater transparency to the overall marketplace. And so we take the position in the guidance that to the extent that you are registered as a U.S. swap dealer, even though you are organized and operating from outside the U.S., all of the entity level and transaction level, including the reporting requirements, apply. But then we scale back, recognizing there may be instances, such as when a non-U.S. swap dealer is transacting with a non-U.S. counterparty, that the supervisory interest of the home jurisdiction may supersede ours, and we scale back. But to the extent that the counterparty may be related to the U.S. person, for example, guaranteed by a U.S. person, we believe that we do have proper supervisory interest. But again, in recognition of principles of comity and the need to minimize conflict, we will recognize substituted compliance.
Thank you, Carlene. Commissioner Wiegand, do you have any questions?
Two questions. One is related to some of what Emile said, and also relates to what Carlene just said. There seems to be reflected in the comment letters a real resistance or aversion to having foreign firms register here with the CFTC. But nonetheless, in a lot of instances, we do recognize, I have to remember exactly what the document provides for, Carlene, so correct me if I have this wrong, but even if you're registered with the CFTC and you're located abroad, there is the availability of substituted compliance. Isn't that right, Carlene?
Yes.
So there's also this other concept that I'm less familiar with concerning recognition, which is something that's been done at the CFTC for quite some time. So I'm just kind of curious, what, as a practical matter, what's the difference? If you have a regime here at the CFTC that requires registration, but you allow for substituted compliance with entity level requirements, how is that different from the historic practice of the CFTC and having this recognition regime? Isn't it essentially the same? And again, back to the original way I phrased the question, there seems to be this real aversion to registering, and there might be a good reason not to require that when it's not necessary. But if all we're doing is requiring registration but permitting substituted compliance, how is it that that's terribly onerous, and how is it that that's different from the way things have been done here at the CFTC by way of recognition in the past? Yeah, Emile or anyone else?
I know ESMA has a view, but I think our view is simply twofold. The first issue is the scope of registration. It has to do with the definition of U.S. person. Yes, we acknowledge that everybody who meets the test has to register as a swap dealer. That's in your proposition. The point is that we believe that the scope of that test is too wide. And we don't believe that, as Carlene has just explained, that it really goes far enough to say, you register with us, but if you're not American, you're not a US trade, but it's a trade between two Europeans, then American law doesn't apply. Yes. How and why would you want to apply American rules to a trade between somebody in Germany and Italy? I mean, that is not flexibility, that is plain common sense. What we would point out is that the definition of US person is simply so wide that it should not only exclude a trade between two non-Europeans, and one of whom might actually be registered here, but it should also take into account trades between a European and a United States counterparty. And that is where the points kick in that Emile has raised. So that's who has to register. We think that definition of a US person really is far too wide. And then the consequences of registration. Colleagues around the table have pointed out it is not clear what the consequences of registration are. We hope that will be clarified soon. Secondly, the scope of substituted compliance. Why only substituted compliance for one set of level of transactions? Why not for entity and transaction level requirements? That's, I think, the second point. The third point is, yes, we are cognizant of what Dodd-Frank says. Even if it would not be possible for you, for legal reasons, as Emil said, we cannot interpret your statute or your act for you. Ideally, we believe registration should not apply, and you should have a clawback possibility if a foreign jurisdiction does not apply the rules, the comparable rules that you decide on in first instance, you claw back that requirement. Even if you do require registration, why not require registration in a far more flexible and a far more applicable form? Why does it have to be so heavy-handed? Why can it not take some form of notification? You register, but the consequences are not as heavy as set out in your draft guidance. I think that again would reflect that principle of, as Emil has pointed out, not just of flexibility, but of proportionality in the application of the rules. But I know that my colleague, Mr. Planta from ESMA, also has some points to make.
Nothing to add.
Thank you. And just a viewpoint from a third jurisdiction, that is, in the past, of course, we have found the equivalence test in the European Union very rigorous as well. But I think there is an important difference here that if you tie this to a registration, of course, that at least in our eyes would automatically mean that it will be a case-by-case judgment or an entity-by-entity determination, whereas under this equivalence test, of course, we will be recognized either as a regime or as an authority. In fact, in our case, we, in fact, would still like, for example, to have foreign CCPs to be designated by us, but we make those conditions much less onerous as compared to domestic CCPs, for example. So I think it is possible to have a registration system which is much less onerous, but as it appears, and I'm quite sure you're working on it, at the moment it looks as though you have a very broad definition of what direct and significant would mean, whereas your substituted compliance would appear very much case by case and not as certain as some market players outside of the US would like it to be. So that is one's perspective.
Just my other quick question was a process one. And that is, I'm just curious what the group thinks is further required in terms of coordinating the efforts of the CFTC and our big brother agency, the SEC, and the rest of you at the table. Yeah, obviously, folks have been filing comment letters in response to our documents. So there's input from folks here as to the substance or what the substance of our rulemakings should be. There are also things that we can do in our documents with respect to when we time the effectiveness of our rules, especially as it relates to reaching outside of our borders. But I'm wondering if there's any other things that the group thinks that needs to be done. In other words, this is one GMAC meeting we're having today, and there are a couple of meetings that happened before today. But do folks feel like these sorts of meetings are helpful and are more than required, or is it enough just to continue commenting on the CFTC's documents and coordinating the effectiveness of when folks have to comply with the CFTC's rules?
Yeah, thank you very much for that question. Yes, we want to be seen to be acting, and we want to be seen to be solving problems. And I personally believe that we can solve a lot of the problems if our principles of all the regulators present here on the 28th of November could agree on a kind of common interpretation of foreign person which would go much more back to the more conservative approach of linking it much closer to residence and establishment and only going beyond to the absolute necessary, and that should be discussed. For that we will put options on the table. So, but the objective would be to have an agreement of the principles to reduce to the absolute minimum and necessary the definition of what is a foreign person for the application of our rules. One, and two, second action, that we would agree amongst ourselves on a broad application of substituted compliance linked to stringent conditions. Not stringent in the sense of operating the application. That should remain linked to outcome, not line by line, not rule by rule. That's not what I mean, but the other conditions which I mentioned in my short introduction. So if we do these two things, reduce considerably the extraterritorial reach of the rules and broaden considerably the application of substituted compliance, then I think we will show to industry that we have solved a big chunk of possible, likely, probable conflicts, inconsistencies, and we have taken away a big part of the burden of application by industry of these new rules on mandatory clearing, mandatory reporting, mandatory trading, which will be mandatory margining, which will be daily obligations on hundreds and thousands and millions of contracts. So if we do that, and we can do that in the short term, that's the short term, we can do that. So I think it is hugely important that between now and the 28th of November, that none of us moves and goes out with new statements about cross-border application rules, because that would preempt the goodwill which we have now in the discussion ongoing. Then on the 28th of November, every investment should be made that the principles come to a consensus. And then we go home and implement these short-term consensus rules. Part of that must also be, in my view, the short-term includes also the timing issues, the sequencing. And I do support the European Commission. I can speak here for my institution here in this respect. We are willing to show flexibility, but this flexibility must be linked to a clear commitment by all the jurisdictions to come in line with G20. And I think no jurisdiction disputes that. So we are exactly on that line. We are all on that line. So we have no reason to believe that that would not be, and that is really something nice to take note here, you see. But with that, these three short-term actions, so reducing extraterritorial application, broadening the substituted compliance, and dealing with the timing issues, then I think we have the short-term plan. The next step is then the gaps, which we should not prejudge here today, because, as Gary rightly says, maybe the problem is less than it looks like, you see. So let's do first the work of analysis of the impact and see whether and what we need to do there.
Thank you. And now I'm going to turn to Ron for any questions he may have.
Thank you, Commissioner Summers. And first of all, I want to thank everyone. If I were grading this discussion, I would give you all a very high grade. But I'd like to raise another issue that hasn't yet been addressed completely, and it deals with a lot of these other issues that have been raised. I mean, the definition of a U.S. person will obviously trigger this $8 billion de minimis test and whether registration is required or not. And then if you have to register, then you got the substituted compliance issue. Well, the CFTC for 25 years have already dealt with this issue under Part 30 regarding futures. It really is an exemption from registration as long as the non-U.S. entity resides or located in a country that has a, quote, comparable regulatory system. And so therefore, what's the difference between futures and swaps? And the key part is that futures are cleared globally. Swaps have been bilateral globally, historically. And all of you, at least the countries around this table, are all talking about you either there or getting close to a mandatory clearing. And I'm one of those proponents of clearing. I think clearing reduces systemic risk significantly. And if you just look at AIG financial products, they would not have lost $185 billion if they were required to clear the products. They would have to put up margin. There would be capital requirements imposed. And they would not have had the cash or collateral to meet any of the size. They may have lost $1 billion. They may have lost something smaller, but they would not have lost $185 billion because they didn't have the cash. And a lot of the swaps, because margins are not distributed, afforded between the parties, where in clearing, both parties put up the margin at the clearinghouse. And I'm a big believer that clearing reduces systemic risk, and systemic risk is, to me, the heart and soul of Dodd-Frank. And so my question to you is, if swaps are required to be cleared, and they will be, it's a timing issue, I think, more than a what-if issue, is that really the proper analysis, or is it really the substituted compliance? Do we still want a comparable regulatory scheme in place, and whether it's November 28th or whatever that date might be, where all of you come up with a, quote, comparable regulatory, the definition of a comparable regulatory. So I'd like to throw it out. How important, from your perspective, is this clearing aspect to, quote, reduce the systemic risk? Or is it really more of just looking at the comparable regulatory or substituted compliance type analysis? Which is the higher priority from you, or is it a combination of all of them? Thank you.
Patrick.
Chairman, I give you the highest grade for that question.
Your grade is depending on.
My grade depends on my answer, but your question was excellent. Yes, sure, futures cleared globally. We all around the table, everybody in this room is thoroughly 100% behind clearing, central clearing of swaps. The risk in a 647 trillion market today focuses that mind. We need to clear as much as possible and increase the safety in our system. There's no disagreement about the objective. Where the discussion is, how do we do this? How do we move a bilateral OTC market that is global into a cleared space? So you have the interaction with a market that is not used to central clearing. You have an interaction with a market that is subject to very, very different incentives from the futures space. And you have an interaction with a global market. So that leads us to the following three conclusions. We can only capture that market, regulate that market, if we have consistent and seamless international rules. As colleagues around the table have said, the one thing we must not do is come up with a regulatory system that incentivizes arbitrage and could potentially shift trades outside of the regulated space. Masakono started off at the very first presentation of this interesting exchange of views, commenting that there is already evidence that firms are doing this. So that's the first point. We need to do this internationally. We need to do this credibly. My second point is we need all of the requirements to apply. It's not which requirements apply. It's and. It's not either or. All of these requirements must apply. And it brings me back, and I really apologize if I continue to make this point. If we have rules that apply to the same trade and to the same entity in different jurisdictions, you immediately, inexorably, as an absolute scientifically 99.9% Gaussian stochastical probability, introduce a potential conflict, inconsistency, and overlap of requirements. And you immediately, therefore, need to answer the question, which rules and requirements apply, except for that 0.01% of cases where there is absolute identicality of rules and requirements. That is why we have to apply this comprehensively, seamlessly, and we must address these issues that are real issues. This is fact, it is not fiction. And as my colleague Emil Paulus said, we have 36 days to do this until the end of 2012. I come from a civilized jurisdiction where we have long Christmas holidays, or you call them holidays, we call them Christmas holidays. We have 26 days to do this, so time is short, sir.
Thank you so much. We are running a little bit behind schedule this morning, but Commissioner O'Malley has one final question. Quick question.
The issue is on privacy. Obviously, substituted compliance works really well when we can get access to some of the data, and I think everybody here has talked about good sharing of data. Are there privacy concerns that we need that might impede that coming out of European or Asian regulators?
I think probably Stephen can help on this. Easter has made a submission to CFTC where they have surveyed, if I remember correctly, 23 jurisdictions. And they all have some sort of a local privacy law. And out of the 23 jurisdictions, they have identified 7 jurisdictions that are very problematic. Those are the ones that even with client consent, you may still need the regulator to give consent, or if the client consent has to be on a transaction by transaction basis. And obviously, we need to sort of like resolve this. I think from the market participants that we've been talking to, they are trying to deal with this issue. But as I mentioned earlier on, it will take time.
Being mindful that we are running a little bit behind schedule this morning, I was hoping that I could open it up for GMAC members to have questions, and I'll do that really quickly if we have questions on either side. Steve.
Turned on? Oh, there we are. As chairman of the International Swaps and Derivatives Association, you might imagine I have a lot to say following discussion, and you're correct, but I will limit it, Chairman, to some observations on one question. But first, I think it's really good that so many global regulators have attended today, and thank you for your forthright comments. A dialogue like this is very healthy. I'd like also to say that ISDA understands the challenge globally and the issues. We get feedback daily because ISDA has 800 plus members in 70 countries. But we strongly agree with the G20 goals, and I strongly agree with many of the sentiments that you have expressed this morning. We must work to avoid overlap on the one hand, but close loopholes, avoid inconsistencies, inefficiencies, impossibilities, timing differences, and inappropriate coordination will be harmful to markets. And for the first time now, we're seeing some real hard evidence of harm to markets because certain non-US banks will no longer trade with US banks. I've been on a trip through Asia recently, and this is very clear to me, and they're avoiding trading with US banks onshore to avoid the registration requirements of Dodd-Frank. So that's just one example of how rules can harm liquidity and increase costs. And just to highlight a couple of industry perspectives, not all of which have been addressed this morning, I think the one overriding goal for us would be to have a level playing field for market participants. A US or European bank, when trading with a European client, the rules must be the same. Similarly, for a US client trading with a US bank or a European bank, the rules must be the same there. We can't have one party seeming to be more attractive, one bank seeming to be more attractive than another, or to have a pricing advantage. Even better outcome would be to have the rules the same in both jurisdictions, but that's the nirvana of harmonization mentioned by Mr. Palace earlier. We look forward to that, though. Also, Mr. Palace mentioned the burden. That cannot be underestimated. And as I say, ISDA absolutely supports the G20 efforts to reduce systemic risk and to close loopholes, but an implementation burden caused by scope extending beyond G20 goals, by jurisdiction overreach, by short deadlines, uncertainty, impossibilities, dual compliance, rules that add to systemic risk or not rather than reduce it, will stretch regulators, end users, dealers, and will harm liquidity and harm parties' ability to trade. And then just touching on a couple of micro points, Mr. Kono earlier mentioned a deferral of the application of CFTC rules to non-US persons would be useful. We strongly agree with that, including deferral of onshore, those rules applying to onshore US banks trading with non-US persons. And we also agree that certain transactions should be excluded from the de minimis calculation for non-US persons, including transactions with onshore US swap dealers. That would overcome the issue that I raised earlier as my evidence point. So sorry for being so long. On to the question now. This area is more complex than margin, which itself is very complex. We need a very coordinated approach globally that's efficient, effective, comprehensive, that avoids overlap, closes loopholes, but not so elaborate or granular or overburdensome that it's unworkable. And I hope that the committee doesn't become a comedy or a farce or even worse, a tragedy for markets. So my question is, and we warmly welcome that work that the BCBS IOSCO has done through the WGMR in the area of margin. I would like to ask the community whether a similar group under the auspices of SSB, BIS, IOSCO would be helpful with regard to resolution of these cross-border issues.
Masa, would you like to take that in your role as the chair of IOSCO?
Yes, thank you very much. Actually, first, of course, I was going to mention that up to now, IOSCO has been less than ideal in actually dealing with this issue. And it is certainly the case that for a standard setter, a global standard setter, it is difficult to deal with the types of issues that we are discussing today, which are very much in dealing with the unintended consequences of slightly differing rules being implemented in different jurisdictions, but which are in principle at a high level very broadly convergent, or at least share the same objectives. Having said that, at IOSCO we have already decided to create a new work stream to deal with cross-border issues. Now, I fear that work at IOSCO would not be quick enough in time to deal with issues that will be arising towards the end of this year. But on the other hand, I can certainly state very clearly that we are aware of the issue, and to the medium to longer term, I would definitely bring this back to IOSCO and deal with it. Thank you.
Thank you, Masa. I think we will have the entire afternoon to hear input from all of our GMAC members on all of these very important issues. So I'm going to close the morning session and move on to lunch. I cannot express the gratitude of this commission and of my colleagues we all agree that it was enormously important for you all to be here and to agree to have this type of open dialogue, helping the market and the industry understand the challenges and these complicated issues that we're all dealing with. So thank you all so much for participating this morning. We are hosting a lunch downstairs right now for all of the regulators here and our GMAC members. And we will come back to these important issues this afternoon at 2 o'clock. Thank you.
Thank you.
And try to get started with the afternoon session. I want to reiterate how helpful I think we all found the morning session and the topics that are going to be discussed this afternoon with market participants. The members of the Global Markets Advisory Committee are the same topics that we discussed this morning with the international regulators, but hearing market participants' perspectives. And so I think it's going to be equally as useful for us at the Commission to have this afternoon discussion. I'm going to turn everything over this afternoon to Ron, and he's going to lead the discussion in our 3 different topics this afternoon. And of course, if there are other topics that members want to get into and discuss, I encourage you to bring any other topics related to our cross-border releases into the discussion and dialogue this afternoon. But we thought we would start with the 3 topics that seem to receive the most comment. So I'll turn it over to Ron.
Again, thank you very much, Commissioner Summers. So you are all my students, and we want a very vocal, open discussion. And the first topic we're going to talk about, as Commissioner Summers mentioned, is the U.S. persons. And a lot of that was discussed this morning. And let me just throw out some food for thought. And I'm going to look to each of you for your comments and thoughts on each or some of these issues. In October 12th, the CFTC put out a no action letter that limited the definition on a temporary basis of a U.S. person literally to U.S. people. Persons resident or in the U.S., companies that were located or incorporated in the U.S. And for the temporary basis, remove the guarantee part language, remove the affiliate language if they're outside the U.S. And part of that analysis is there are other definitions of U.S. persons under CFTC rules, under 4.7, Part 30. So my question to all of you is that the proper standard? Should there be one standard among all CFTC regulations, or is there a need for a difference? Or thought for futures, we need one definition, but for swaps or something, we need possibly a different definition? Or is there a way in which we can have one definition across all applicable CFTC regulations? So I'd like to just throw that out for discussion. And Bonnie, may I start with you, please?
Sure. I mean, just to be clear, there really isn't a U.S. person definition in the futures markets right now. I mean, there is, I think that for commodity pool registration, commodity trading advisor registration purposes, folks focus on the U.S. ownership of a commodity fund. But you know, we have functioned in the futures markets without a definition. And Ron, I think that you point out a concern that many futures professionals have, which is that if this does become the global definition for all of the Commodity Exchange Act, there are real concerns associated with that, because the futures markets have, in effect, FCMs like my firm have come up with a very rational approach, but a much simpler approach than the one that's been proposed by the CFTC. So I actually would advocate that when we think about a new definition of U.S. person, to the extent that it's going to spill over into the futures world, we have to think very seriously about a phase-in period, an interim period, because I don't think futures professionals have used anything like the definition that is being proposed. So,
but just to go on, expand, what do you believe that proper definition, if you were the 5 commissioners all in one, what would you think the proper definition of a U.S. person? Is it the October 12th limited definition, or could it be more expansive? What are your thoughts?
Well, I mean, I guess, it's hard to talk about the definition without going through the entire analysis of the proposal. I'm very concerned about the CFTC's proposed definition. And I think many people, both on the buy side and the sell side, are concerned. And in part, we're concerned because it's both complicated to apply. And again, I'm taking this down a notch from where we were this morning. We were talking very high level about jurisdictional lines and where one jurisdiction's regulatory focus begins and one ends. I'm just talking about this from a very practical standpoint, which is that as a swap dealer and as a customer of a swap dealer, we're going to have to make determinations based on this proposed definition as to who's in and who's out. And I think the CFTC proposal, in trying to be broad, in trying to worry about evasion, really was overly expansive and quite concerning. And not only that, I think there are some internal inconsistencies that might potentially lead to a single entity being characterized both as a U.S. person for U.S. regulatory purposes and as a non-U.S. person for non-U.S. regulatory purposes. And, I'll leave to all the regulators who were here this morning to work out who's going to regulate which swap dealers, but I don't know how my clients and how Goldman Sachs are going to figure out just whether someone's within Dodd-Frank or not. I do think, I don't want to take too much time, but I do think that's particularly true for the commodity pool and collective investment vehicle test that's been established, which could easily lead to a non-U.S. domiciled entity. At the very best, being both a U.S. person and a non-U.S. person based on a single point in time, at the very worst, actually potentially changing its identity as a U.S. person from day to day. So,
Thank you. Thank you. Richard, do you have any thoughts from your perspective?
Yeah, I guess given that I'm surrounded by a lot of lawyers or legally qualified people, I'm going to try and make some comments that are perhaps broader brush and more commercial and perhaps more from the client side. So if you'll excuse me not addressing very specifically the U.S. person definition, where people like Bonnie and Bob are far better qualified than me, I wanted to make 3 main observations around what I am experiencing in the markets in Europe, and that applies to both the exchange level, the intermediary level, and the end customer level. The first thing is that it is clear from this morning's conversation how difficult the subject matter that we are dealing with today is for those that are lifelong experts in the US regulatory environment and the political environment. If you try and remove yourself to the positions of an end user customer, the levels of complexity here are quite overwhelming. And I think to one of the comments you made this morning, Mark, about what is such a big deal about registration, it is fear of the unknown, I think, at its most fundamental. And the fact that by definition, given the environment in which we are living today politically, unknown rarely results in good things. It can result in bad things. There will be a big resistance to anything that is happening there. The second thing is that as a result of that, there is this big timing consideration, which is that there is concern that many of these deadlines are imminently upon us. There are indeed lots of examples of where relief is being applied, but the relief is until July next year or until the end of this year. They're sort of 6-month relief periods that in many of these customers' cases are, quite honestly, still very, very constrained. And in a large number of cases, I am working with customers in Europe who are just saying, we're not going to do anything until we know what the rules are. And that means we will stop trading until we do know what the rules are and we have managed to implement. And I think given the fact that sitting in Europe, there are all the European regulations to digest, prepare for, and comply with, we've got the same issue then of being multiplied up, of having the US regulations to consider as well. Which brings me to my third point, which is the impact on the market. And we saw the comments from the JFSA this morning about anecdotally feedback that there are impact on the markets. I think I would highlight 2 or 3 things that I'm seeing going on. The first thing is that whenever there is a change in market structure or a change in regulations, it is quite normal for the level of turnover in the market to decline while people digest and adjust. I think of the examples of the futures industry where in Europe, for example, we had listed options traded on the floor in a pit, moving to a call-around non-central limit order book market. Volumes declined by about 1/3 for a 12-month period while everyone adjusted and then got used to it, and then they started to pick up again. We are now in an environment where industry volumes are declining year on year. Most of the examples I've seen in the past are where we have seen double-digit compound growth upwards. So the likely impact will be even more significant to market liquidity than has been the case in a lot of transitions before. So I think the first thing is we will see really quite significant declines in market turnover as a result of the changes. The second thing is that I think a point that I think is very important for the CFTC in particular to keep their minds on is that as the regulator of the majority of the over-the-counter derivatives market in the new environment and all of the futures industry, ex-swap security futures, you are an organization that has oversight for both of these new areas of activity. I think that the complexity and the uncertainty around the OTC side could have some quite interesting dynamics about whether bilateral over-the-counter derivatives that are traded today end up in a cleared, CEF-based over-the-counter derivatives environment, or in fact whether they go all the way to full futurization. As we heard a lot at Expo, the FIA in Chicago last week, it is a theme that clients over the last 3 months or so are increasingly thinking about. Now, it may be an unstated objective of some policymakers, in fact, to achieve just that, move it all the way into a central limit order book with a regulatory environment that's been around for a long time. But I think we need to be very conscious of the fact that there are people out there that are beginning to think that the over-the-counter derivatives environment is too complicated for them, certainly in the medium term, and that in fact a move into full futurization is something that is worth considering. You look at the ICE conversion to futures of some of their energy products, the launch in Brian's case of the swap future there, I think it's indicative of the changes that are there. So I think the 3 points I really want to make then was around how overwhelmed customers really are at the moment. It is incredibly daunting. The fact that I think this will have an impact on market turnover, and I think thirdly it will have an impact on the market structure that we end up with. And I just really wanted to sort of place those comments in the context of much of what we discussed this morning.
May I follow up with a question? Because I think you raise a very important issue in this, well, I'm going to call it conversion from swaps to futures. And I know it's a relatively new approach. Maybe Brian can add to it as well. But once you have a futures, Part 30 applies. And you have all this comparable regulatory thing. We talked about it briefly in the morning, but I really want to expand on that. I thought one of the creative approaches that ICE and CME or whatever, by converting a swap to a futures, you bring in, it is a more structured regulatory environment, but there's a lot more exceptions or exemptions under Part 30 that would not apply in the swap world. I wonder if you had any thoughts on that or had any discussions at all with your clients along those lines.
So I think the answer is in my experience, very much depends on the customer. So there are those who are very comfortable with the use of highly standardized products that fit perfectly well into their risk management model. Furthermore, you have a number of customers who, in fact, would like to see the futurization because investment mandates, for example, do not authorize over-the-counter trading, but do actively encourage listed trading. So there are some who will be entirely comfortable. There are others where the risk management process needs to be far more tailored, and the futures product does not answer the question or does not solve the problem that they have around risk management. And I think to try and put a percentage number on which would fall into which category, I wouldn't attempt to try and judge. But I think it is fair to say that, in my experience, there are plenty of examples of people who would say that the futures solution does not meet their needs. and that they, hence the really significant concern that they have at the moment. I guess my other point on Part 30 is more a question, which is that in the event that we redefine, in other words, if this CEA definition applies to all of it, are we not actually going to reinvent the futures rules, as Bonnie said, in which case does Part 30 still survive? I don't know.
And that is a big policy concern and issue as well. Brian, can you add some thoughts to that, if you don't mind?
I totally echo what Richard just said. I mean, in the context of offering the deliverable swap futures contract, it's not been presented in such a way to replace swaps. You know, it's presented in a way to offer an additional mechanism or instrument for users of the swaps market to have an alternative venue, and not everybody is going to be able to meet the criteria, the requirements from a capital perspective and a margining perspective. Yet today, they rely on availing themselves to those particular instruments. We've also have found that the interest in introducing the deliverable swap actually provides an augmentation to the existing business model that exists today for the swap market in particular. But if I could possibly go back to the original question with respect to the whole definitional aspect of things, and you know, God knows the Commission has undertaken a great deal with respect to all of the rules associated with Dodd-Frank, but I'm just speaking as a market itself that is dealing with questions across Europe and Asia daily on this as well as other topical matters. And while there has been some progress in the context of trying to clarify the definition of what constitutes a U.S. market participant, there is still mass confusion out there. I mean, day in and day out, my team is working with the end users who are asking us, do I fall under the definition of a U.S. person? At what entity level or what transactional level does that apply? And so we're all trying to bring ourselves up to clarity in that respect. And one of the things that I don't think has been clearly defined or articulated is if we're dealing with two, you know, non-U.S. participants, and they're absolutely non-U.S. participants that are doing a swap, which happens to clear through a U.S. Clearing organization, does that now fall into the definition for the de minimis standards as a swap dealer or a major swap participant? And that's something that, you know, we would, you know, adamantly say it should not and does not. However, it's not really clear.
So may I follow up with a question that you just raised? What do you think the proper definition of a U.S. person is? Should it be the October 12th interp? Should it be more expansive than that? Do you have any thoughts on, or does CME have a position on what they think is the best definition for the Commission to consider?
Well, I think that the October 12th interpretation has come a way to giving that clarity. I think we still need more work just from, you know, what we've been experiencing with our client base, what we're hearing this morning. There's still unanswered questions with respect to the application at the various entity levels and how that may or may not apply.
And as a follow-up, let's say one of your clients does, or firms does do business, quote, with U.S. persons. Does the CME have a position that the $8 billion de minimis should be different at that firm, even though it's not in the U.S. but is outside the U.S.? Should it be a higher test? Is that the need, or is the $8 billion amount for the de minimis an acceptable level from your perspective?
I wouldn't say it's an acceptable level from our perspective. So it's you know, it's the requirement that is out there that, you know, speaking again from experience, is creating a great deal of unrest just with the standard itself that we're trying to work with.
Commissioners D'Amalia or Whedon, feel free to...
Just a real quick question, sorry to interrupt the flow, but Brian, you said that the U.S. person definition and the no action relief went a long way towards clearing things up. Are you aware of any questions or issues related to that definition? I know that in the current relief that ends relatively soon, but it'd be useful for me to know whether there are any questions or concerns that people in the markets have had over that particular definition. Acknowledging it's not the same as what was in the exemptive order and the guidance, but that specific definition.
I think, again, as we're all learning in this process ourselves, and as we're continuing to deal with idiosyncrasies that are presented to us, basis various differences in org structures, whether it's an affiliate, whether it's a branch, whether it appears to be a combination of one or the other, how does this apply, and how I think a lot of the questions also turn to substitutability of regulatory regimes that are in place. So if they're all intertwined, the registration, what defines, whether or not you're a swap participant or you're not a swap participant, if you fall into this category and you're in a different regulatory regime, how might they get recognition for a regulatory regime that is comparable? So there's all of these questions that are circulating in the marketplace that is creating this confusion.
Bob, you have any thoughts on the definitional issue?
I can't, without spending a lot of time like diagramming words, get into the nuances of the definition. I can say this, that the no action definition went a long way toward addressing customer concerns and comments, but not all the way. And I think part of the lingering concerns are with the temporary nature of the relief, and as others have noted, the overall complexity of the regulatory regime. And there are still a number of U.S. counterparties who simply are taking the view that it's too complicated for them to figure out. They don't know whether they're going to be a U.S. person or not a U.S. person, or their counterparty might be a U.S. person when everything is said and done, and that they are considering curtailing trading with anybody who might have a U.S. nexus. So I think there is still an enormous amount of confusion out in the marketplace that is just temporarily been tamped down by the no action letter. But people are still scratching their heads about what this market's going to look like.
But Robert, I'm not hearing you say that the confusion stems from the meaning of the exact words in the no action relief. It's related to these other.
I think that's right. I mean, I think we can discuss whether the actual no action definition is the perfect definition, a good definition, or whatever, however you want to categorize it. I think the confusion is with what the rule is going to shape up to look like in the long run, and an overall fear about exposing yourself to the U.S. regulatory regime.
I think that's it, Commissioner Weegin. I don't think people are as focused on the no action definition because they're so focused on the potential next definition. And so if we had some sense that that's what we were going to work with, and then we could, do what Bob suggests, which is actually parse the words and figure it out, that would be one thing. But, right now people are wondering about, do I have to worry about how many U.S. owners my commodity pool has on Tuesday? Or do I have to worry about what it means to be indirectly owned by a U.S. person? Or when I face a swap dealer, do I have to think about things that I wouldn't necessarily know, which is like, are they guaranteed by a U.S. person, or are there U.S. persons in their control group? So I think that, in some ways, there's not a lot of comfort associated with the no action definition because it's so concerning that the next step might be more uncertain and more unclear.
I think, just to follow real quickly, and then I'll get off of this pony here, but it would be useful for me to know if there's something about that definition as it appears in the no action relief that is somehow insufficiently clear.
I think that's something we can give to you. So I don't know that we did that for this presentation. So,
Steve, any thoughts from your perspective or ISDA's?
There is confusion. I'd echo what Bonnie said earlier, that we have thousands of clients who are waiting for guidance here. With regard to clarity as to the definition, I think it has to be very precise. So language such as includes but is not limited to, for instance, is
very broad. And I understand maybe that's in the works for getting changed, but that absolutely is something that's very important. And then another thing, once we do arrive at a final rule, I think this has been mentioned already as well, but there's a timing issue as well. It's going to take some time to implement a proper phasing approach once the rule has gone final, would be adequate. And I think in our letter we thought the whole ET should have been a rulemaking rather than guidance. So it's probably too late to, that horse has left the barn by now. But to allow some kind of comment period once a proposed, a proposal is out there to make these modifications, I think will be useful.
Chuck, from your perspective, any thoughts? Because your exchange is also doing a little bit of a conversion practice as well.
Right. Yeah, I think in our experience in the energy markets, actually in all the markets, but I agree with Brian's comment earlier about all these things work together, all these provisions. I mean, I think what happened in energy, the marketplace, they looked at the de minimis requirement. That was number one. I would say number two is the U.S. person definition. So it was actually a global impact of, do I want to keep trading swaps? And with those concerns in mind, I think they looked at the energy swaps that they were trading, and they said, these are largely standard instruments. They could certainly be futures, notwithstanding whatever differences there might be in execution, alternatives, and so forth. But from a product structure standpoint, the marketplace told us loud and clear we would prefer these be futures, and therefore we get rid of these concerns, and we don't need a certain amount of customization ability and a lot of flexibility around these instruments. I think so it may be that for some OTC markets or some instruments in some OTC markets that are standard and are liquid and are cleared or easily cleared, the marketplace may make that decision, and I don't think that's necessarily a bad thing. It may be there are other parts of the swaps market that, particularly where end users are involved and there's a lot more customization, that having business conduct rules and a lot of the other swaps dealer requirements are appropriate. And if you look at it that way, then a broader, back to the U.S. person question, a broader U.S. person definition may be appropriate. If you have a different view, then you may come to a much narrower definition of a U.S. person. I think the last point I would make on that, though, back to futures, is one characteristic of the futures market internationally is a heavy reliance on recognition and equivalence, and I think that's part of what's made it successful and kind of globally embraced and globally understood. And so I do agree, I think, to some extent with the European view that the U.S. solution for swaps would ideally have more of that element than it has today.
Dan, as an NFA is one of the principal SROs involved in this, especially in registering and auditing swap dealers, can you share some thoughts from the NFA's perspective on this issue and how broad or how narrow the definition should be?
Well, what we tend to think about it from our point of view and what it means for NFA and what are the resource implications for NFA. And it's also intertwined with the concept we were talking this morning with substituted compliance. If, in fact, the definition is broad, and if, in fact, a large number of foreign firms, instead of being, even if they're subject to a comparable regulatory regime, instead of being exempt from registration as they would be on the futures side, they are now required to register, and they're subject to some, but not all, of the CFTC's rules. Well, then what does that mean for NFA? Presumably, if these firms are registered, they'll have to be members of NFA. That means that NFA is going to have to be monitoring these firms for compliance, and the question becomes compliance with what? Are we monitoring them for compliance with the CFTC rules? Are we monitoring for them compliance with the CFTC rules and for those rules for which there's substituted compliance? Which is to say, does NFA have to have expertise in the regulatory regimes in all the various foreign jurisdictions and understand those rules so that we can monitor for compliance? And that has some resource implications, to put it mildly. So, from our point of view, what we're sort of grappling with is trying to make sure that we understand the scope of our responsibilities. And obviously the definition of U.S. persons and the concept of substituted compliance that has a very direct impact on what it is that we're going to be expected to do.
Just on that one point, and I think Dan raises a very important issue for all of us, and that is registration the important issue, or is it the compliance with the underlying regulation the more important issue? And if it's the latter rather than the former, what should those standards be? You know, the comparable regulatory regime or the regulatory recognition or the substituted compliance. Does anyone have any thoughts? Is there one part more important than the other, or are they both equally important?
I think there are two answers to that. The one is a perception one, and one is a legal answer. And I'd just like to answer. I'm going to answer the perception one. And the perception is that registration, despite the fact under Part 30 you already agree to comply with all sorts of things, the registration itself is I'm going to use a very emotive word, a scary thing, because it leads to things that are perhaps less well known than the Part 30 model that people have been used to dealing with. So I think a lot of this is fear of the unknown and where it can lead to from a perception problem that is causing some of the real fear. I'll let Bonnie and Bob talk more to the legal side, but I think the perception side, a lot of it is fear of the unknown.
Can I just, I'm sorry, just when I think about registration, and I think if you look at the legislative history between sections for sections 882 and 883 of the Act, I think a large part of the benefit of registration is the vetting process to make sure that the people that are going to be licensed to do business are in fact fit and proper, that they meet certain standards set forth in the Act, that they've never had these types of problems. I assume that part of the determination that there is a comparable regulatory regime would mean that foreign regulatory regime has some form of vetting and checking for background. In which case, I'm not sure what the additional benefit of the registration here is as far as checking out the background. Furthermore, with these foreign firms, as part of the registration process, if you're a principal, a foreign print of a firm, we have to get a fingerprint card for you that we can then send to the FBI in Washington, and they'll do a background check. And I've never been entirely sure what the benefit of doing a background check through the FBI's U.S. fingerprint directory of an individual that's never set foot in the United States. There's not a lot of bang for that buck. So, from the point of view of the benefits of registration, obviously it can be jurisdictional, but I'm sure the Commission has other ways to assert its jurisdiction. But to the extent that it's involving a background check, and a background check has already been done by a foreign jurisdiction, I'm not sure what the additional benefits are of the background check.
Dan, perhaps you underestimate the FBI.
Well, Richard, you mentioned, the Part 30 and everything, and Dan, I mean, the Part 30 does require the foreign broker or the non-U.S. entity to either be licensed or registered in their home country or be a member of an exchange in that home country, which is a separate licensing or membership type test. So there is some, whether it's comparable or not is another issue, but there is some kind of licensing or registration issues. Oops, sorry, we haven't called on you yet. What are your thoughts?
Yeah, I want to go back to, I guess, another unintended consequence of this definition. So I think I represent more of the end user side. I don't think they've focused at all on the U.S. person definition here in the States. They understand they are a U.S. person, but hearing what's beginning to happen in the interbank dealer market with liquidity where, dealers aren't being able to trade overseas, I think it's about to come head the U.S. corporations head on. And then also the futurization of these swaps, the benefit for the end users is getting the customized hedges that they probably can't currently get in the futures market. So I think that impact to liquidity is going to be a big concern that really most end users were really thinking more about margin and capital requirements that may shrink their choices for dealers. So I think that's a big concern. And then the other thing I just sort of thinking off the top of my head, hearing about sort of the confusion or how do you track changes to U.S. persons, is there a way to use the legal entity identifier as a leading way? So if the entity does change ownership or gets a guarantee, do they apply for a new LEI? So the market will know that this is not the same entity, or is it just a data tracking field and not really used to help track those changes?
The issue is that the LEI can work once, that's why this all has to happen sequentially. First, you have to have a definition that is something where an entity will know from day one whether or not it's a U.S. person. And then changes in ownership of that U.S. person become much easier. But I think right now with, looking through to ownership of the entity, looking through to how it's guaranteed, how it's indirectly owned, I think all of that means that you have a shifting landscape right from the beginning. And you both run the risk that an entity will change its identity over time as a U.S. person or a non-U.S. person, and you also run the almost inevitable risk that they will be a U.S. person for one jurisdiction's purpose and not for another. And that, I don't think that's workable. As I try to think about developing a compliance program around that kind of uncertainty, I don't think it can happen. And I think there are fixes to the CFTC's longer-term proposed definition that can make it work, but it requires recognition of some of its internal inconsistencies that I think will help with that ongoing kind of transition.
Dave, from a U.S. futures exchange perspective, any of your thoughts?
I'm like all futures exchanges. I'm a little confused as to why people don't use the futures market. I'm with Richard. I believe that in the past, the traditional swap business has not used the futures because of the enormous profits that were built into it. And if they had to bring these types of transactions onto an exchange into centrally cleared, those profit margins would be reduced. Now, with the incentive to actually move on to not just regulatory incentives, but I think counterparty exposure is a real problem for customers, asking for answers on how they can mitigate that. And as they begin to move on to futures exchanges in the past have always been innovative in their product development, and I think that will continue. I think this is going to lead to a great deal of product innovation in our marketplace, not only on the futures markets, but on the options markets as well. Embedded optionality into a futures, which we don't really have today, but we could. I think we could begin to go down the road of building very similar types of customized products. Now, the question there is going to be, how do you actually value such a product? And that's the complexity. I'm very much against bringing swaps onto clearinghouses that we don't know how to, if they don't know how to value it, how are we going to value it? If our clearing members are going to give the implicit guarantee that if one firm fails, everybody else has to buck up, well then tell me how we're going to value this. The risk committees are going to have to do that. Those types of swaps, those that nobody really understands, those need to be kept away from us. And I think those should eventually die out. I've always said, if you don't like the margining treatment, then you should get out of the trade. But if you do like the trade, then it's worth the margin. Now, when it comes to exchanges, customers who come through clearinghouses, who are backed by the clearing members, they already sign agreements that say you are subject to the jurisdiction of the exchanges. So we know who those guys are. Any large position has to be reported to us. We know exactly who they are, what types of positions that they have. And of course, we can ask them any question we want. We can ask them how to make their positions accountable to us, ask them why they have those positions. We can raise that limit to as high as we want. We can lower it to as low. We could make it zero. Anytime you put a one lot on, you have to tell us why you're doing this type of stuff. So I think that the movement of the swap business onto exchanges is inevitable. I think that's a biased view. But what's of concern is the rules that are coming out have to be very clear that you're moving from a bilateral transaction where two parties are on either side of the trade into a multilateral where it's often the two parties don't know each other. Now, we have this in a very similar way. We have it not with the CFTC rule, but with the IRS rules having to do with dividend equivalence and whether you are dealing with an offshore party or not. And they came out with the bias that said, well, all these trades are bilateral, so of course you know the other side. But then when they start doing these transactions on an exchange where it's point and click, you don't know who the other side is. All of my customers are coming back saying, we can't trade your product because we don't know if the other side is an offshore account. Well, it's a stupid argument because you don't have to know. because it's a chain of payment thing. It's the guy who makes the last payment to that offshore account. Now, these types of confusing regs that are not just the CFTC, not just the SEC, but the IRS and the Treasury, these guys have all similar or different definitions of a U.S. person. I think you all try to get into a room and try to bang this out yourself, because they're all kind of aligned. You all have the similar problem, and you affect the marketplace in a similar way.
Thank you. George, so you're my asset management guy and also my tax expert, so I remember your younger days. Bonnie raises the issue on what type of non-U.S. commodity fund should or should not fall within the definition of a U.S. person. And we all know that tax laws impact the number of U.S. investors in a lot of these offshore funds. Is there a number? Is it a majority test? Is it a large percentage test, 30, 40%? Is it a smaller test that should bring in an offshore fund into the definition? Or should any and all offshore funds be completely excluded from the definition of a U.S. person, in your view?
Well, first of all, I'd like to say that I think that futurization is going to eventually remove a lot of this whole swaps problem, because there are so many advantages to futurization, including for U.S. taxpayers that are not hedging or that are not dealers, that you get mark-to-market tax treatment, at least today we do. On the question of what U.S. person, who's a U.S. person, all I know is I'm a U.S. person. Our company is a U.S. person, and we are not a dealer. We are not a trade association. We're not an exchange. So I am not an expert on which persons should be dragged into this U.S. definition. But I will say this, because the number 8 billion did get bandied about briefly earlier, assuming that foreign exchange does not get exempted entirely, and I guess that's still up in the air with the Treasury, $8 billion is not very much when you consider it's cumulative. Foreign exchange trades may last a day, they may last a long time, but it's real easy to get to $8 billion. And I think that I can't see any way that that is a good measure of systemic risk in the system. I mean, maybe there ought to be a test about what is the maximum you have on any given day or over a week or something like that, because I think that you're going to capture a lot of people who should not have to register as major swap participants, which is a way to not answer your question at all. But I wanted to make that point.
George, can I try asking you a question? Let's say you're an asset manager, you form a fund, you form it in the Cayman Islands, and you've decided that you have the ability to admit U.S. persons into that fund. But, you have a regular redemption policy, and so from time to time, the number of U.S. persons will vary on a daily basis. You've structured it as a Cayman fund because, there are various tax reasons, other reasons why you took it offshore. Do you think that, and obviously this is a leading question from a lawyer, but do you think that it should be relevant where you are in the redemption cycle and where you are during the course of the year as to whether or not that fund is a U.S. person? And asking another question, how would you build a compliance program as a fund manager around determining that and notifying your counterparties on a daily basis of, today I'm a U.S. person, but Wednesday I probably won't be because my redemptions all come in today?
The question answers itself.
Yeah, I know it did.
I mean,
that's why it was a leading question,
you can't have a definition.
You can't do it, yeah.
Where your status changes day to day.
I also don't, I do think that people invest in fund vehicles and managers form fund vehicles for very legitimate purposes, because essentially they've decided that they don't want to have a fund management business that involves dealing with each of the individuals. They want to raise money in a fund, and they want their client to be the fund. And if the fund is a Cayman corporation, it's a Cayman corporation, and the investors in that corporation aren't really relevant to the way the fund was formed or the way it's managed. Not to mention the fact that if your swap dealer had to be talking to that fund on a daily basis about whether it was a U.S. person or not on that particular day, I don't think that's tenable either. So I actually don't think it's relevant. I mean, I think there are a lot of factors that came into the U.S. person definition that I know are very much motivated by a legitimate concern on the CFTC's part to worry about evasion of Dodd-Frank and its responsibilities. But there are lots of anti-evasion policies under Dodd-Frank that give the CFTC and its enforcement division lots of opportunity to go after people, bringing in, you know, tons of entities and persons who really shouldn't be within Dodd-Frank just because of the concern that someone else who was structured similarly might be evading the mandate of Dodd-Frank. I don't think that's the right regulatory focus, especially if it leads to such compliance complexity.
Well, life used to be quite simple. We have a Cayman company.
It's a non-U.S. person.
Well, even if we have U.S. citizens, we have been aware for many, many years that we can't trade futures contracts that haven't got the seal of approval from the CFTC. So, I mean, that was easy enough, and in effect, the CFTC would study the COSPI and decide that, okay, that regime over there is okay. But this whole swap issue has thrown that concept into a cocked hat, unfortunately, and made this infinitely more complex.
Well, I just wanted to underscore something that Bonnie alluded to, and that is in arriving at a U.S. person definition, you have to keep in mind that it gets used from both ends of the telescope. I mean, I need to know whether I'm a U.S. person, because I need to know what rules I need to comply with. But the way the CFTC has structured its rules, I also need to know whether my counterparties are U.S. persons because I need to know what rules apply to them. And in that context, the latter context, it becomes particularly problematic if the definition hinges on whether my counterparty has a guarantee, which might be revoked or removed any day, whether my counterparty's investors are U.S. persons, because I don't have full transparency into that. And it's extremely difficult to build a compliance program around things that I don't know. Unless my counterparty tells me, and my counterparty might not have any affirmative obligation to do that unless I impose it by contract. And to make a big circle back to this morning's discussion, I mean, I really think, and I acknowledge Bonnie's point that many of the concerns that prompted the complexity in the definition are legitimate concerns about evasion. I think the real answer to that is global harmonization and an effective comparability regime where regulators are on the same page and that regulators recognize comparable regulation globally so that these differences stop mattering and you don't have to worry about it.
Well, just on that one point, can I ask you a question? Do you believe a Part 30 type regime should apply to swaps or not?
I'll ask you a question. What exactly do you mean by a Part 30 regime? If you mean a regime in which a national regulator looks holistically at the regulatory regime of other countries and makes a determination that on a holistic basis that regulatory regime meets certain standards, I think that's a very workable idea. It's worked for the CFTC under Part 30. And I think the G20 commitments are high level enough that it could work in looking at whether any particular jurisdiction has met those requirements. If you're looking at a rule by rule, requirement by requirement face-off, it's entirely unworkable to do that. And so I think that's not what Part 30 does, and I don't think that's a workable approach.
Well, Part 30 goes, I agree with 100% what you just said, but Part 30 also says if you're a foreign brokerage firm or non-U.S. entity, and you're located in a country that has, quote, a comparable regulatory scheme, you don't have to register as an FCM. You do have to file a notice and, quote, consent to the jurisdiction. So if you do commit fraud against a U.S. person, the CFTC has a right to bring maybe an enforcement action against you or prevent you from trading further with that U.S. person. But is the consent to jurisdiction for anyone around the table, if a firm has a right to just consent to jurisdiction, but not required to register here, is that an acceptable standard from your perspective?
I think consent to jurisdiction is not a right, it's an obligation.
Repeat that, David, I'm sorry.
If you want to deal with an exchange, you have to abide by our rules. And inside of our rules is a consent to jurisdiction. There's no gray area. Either you want to or you don't.
Well, that's not correct, because as a customer, you are consenting to abide by to your rules, but the customer, you do not have jurisdiction over the customer.
As long as you put that in your rule book, yes, you do. Your consent is in your rule book, and if you consent to my rules, you are consenting to my jurisdiction.
Richard, well, I guess the only way that would work would be that if the exchange's rules require the member to require its customers to consent to jurisdiction by contract. Yeah.
But Ron, I think there's also precedent. I mean, look, it may just be that Dodd-Frank doesn't permit Part 30, and maybe all of us futures guys are, off daydreaming about a happier, simpler time. But the point is that there was also a provision in Part 30. I mean, the CFTC may recall that when the UK firms got Part 30 recognition, there were certain things that were commonplace in the UK that just weren't permitted with respect to those UK firms interacting with US persons, opting out of segregation, that sort of thing. That would be a wonderful way to accommodate some differences. But, look, I do think, I don't know if Dodd-Frank allows us to have this conversation, but it is just a fact that the precedent set by Part 30, I can't tell you for how long a time my securities colleagues have been jealous of me at Goldman Sachs because I got to deal with Part 30 and they had to deal with 15A6. And the fact is that Part 30 was a beautiful, integrated, regime that permitted globalization of the markets without a big sacrifice. So.
I mean, Bonnie, I think you raise a very important point. The comparable regulatory part of Part 30, again, might be idealism that we can even apply that, but it really dealt with customer asset protection. Did the home country have a regime in place that would protect U.S. persons who traded on that regime and have like a segregated type approach? And that was really the principal theme behind it. And swaps, obviously with clear swaps and the rules under 4D of the Act, would apply. So, I mean, I don't know whether that's the principal thing for swaps or other aspects of it, but I just think maybe this ought to be further considered by the Commission.
Well, and even if, and I may be segueing into your next topic, which is, substituted compliance, but I do think that, even if we accept the fact that there's a registration requirement that applies to non-U.S. persons who deal with U.S. persons under the swaps rules, when you start thinking about what substituted compliance has to be, I'm dealing a lot at my firm with issues associated with the internal conflicts rules, and I spoke to many of you about the internal conflicts rules when they were being developed, and they're very specific and they're unusual. The question is, are we really going to start looking at substituted compliance in terms of a rule-by-rule analysis? Or can we look to the fact that other jurisdictions have general rules against fraud, general rules about how one interacts with clients, whether one has to, give full disclosure to clients about conflicts of interest within a firm generally, and couldn't that be the argument for, what substituted compliance is, a general regime that recognizes that financial services firms have conflicts of interest and have to deal with those, or does it have to be, looking for the rule that specifies how the swap dealer portion of a firm can interact with the clearing portion of the firm? It doesn't seem like the latter is the right approach, but I think we're all concerned that, we haven't gotten a clear message from the Commission that the former is going to be the approach in favor of over the latter.
In fact, Ron, I'm sorry. With respect to the comparability determination, that was something that struck me in the proposal, in that under Part 30, that determination is made jurisdiction by jurisdiction, whereas under the proposal, the comparability determination for purposes of substituted compliance would be made on a firm-by-firm basis. Each firm submitting as part of its application instead of the appropriate 4S submission, a compliance plan that would make reference to substituted compliance. So it struck me as being an odd arrangement whereby those determinations would be made firm by firm rather than jurisdiction by jurisdiction.
Well, I mean, the proposal first required the firm to be registered, and then once you're registered, whether or not any of the entity or transaction level requirements would apply on a case-by-case basis to a firm. But as Chairman Gensler said earlier this morning, they got another proposals on their desk. You know, it'd be interesting to see how far those release or changes might occur. I'm sorry.
Bonnie, I'm just curious, is there something in the statute that tells you as a legal reason that Part 30 just wouldn't be an approach that Title VII would permit? Or are you just saying from...
We're going to leave my area of expertise pretty soon. I'm hoping Bob can help me. But I think the fact is that when you deal with with a U.S. person on a swap, you have to be registered as a swap dealer, correct? Whereas the Part 30 regime contemplates that you could interact with U.S. persons in a futures environment as long as you only interacted with them within your jurisdiction. So I'm a London-based broker-dealer. I have a U.S. client who trades on the London and your other European exchanges. I can deal with that person as long as I don't interact with them on U.S. exchanges. I think because swaps are so global, the analysis was different. But Bob, help me. Am I right?
I think you're partly right, but I also think that there are mechanisms by which the Commission could get to the same place through no action and interpretive guidance that would effectively use a Part 30 analogy. I mean, we can parse through the statute, but yeah, Dodd-Frank, you're right at the highest level that Dodd-Frank imposes certain requirements whenever you deal with a swap involving a U.S. person and limits the Commission's ability to exempt people from aspects of the Act, but that is not absolute.
Commissioner Wheaton, just to add to that, 722, which brings in the 2I and the direct and substantial connection test, and then there's another section called 712, I think it's F, I'm not sure. It's more of a catch-all, and anything else that the Commission may want to do. So whether or not you want to use that and expand your authority to bring in these rules, it's sort of a catch-all, or you want to interpret that on a more narrow basis, I think it's up to the Commission to make that decision from that perspective. So I want to change. Oh, Jim, I haven't called on you yet, so I apologize. But any thoughts from your perspective on the U.S. person before we go on?
Well, we at the CBOE haven't really addressed these issues or commented on them directly, but I would reiterate probably most closely with what David had said and also George, in that I think there's going to be a lot of product innovation that'll probably help in moving a good part of this market onto the exchange into a futures contract mechanism. So in fact, we're working on that now with a couple of products where we think we'll make the market that has really been trading OTC to date more accessible to other participants that maybe haven't had the ability to trade those products. Maybe it's credit related or whatever issues they may face with trying to get bilateral agreements in place. So I would fully agree that I think we're starting to see that momentum now at the CME, the ICE, and I think other exchanges will follow in that pursuit.
So I want to take a little.
Ron, just one further.
I'm sorry.
Yeah. One specific thing on the non-US person. Giro reminded me of my point this morning that we've got this fractured global interbank market right now. I think if an exception was made for the foreign banks not to count U.S. onshore swap dealers as U.S. persons for their de minimis calculation, I think that would cure that fractious behavior immediately. So, and then just on the futurization, I feel as though I should respond. I think that absolutely there'll be some shift of liquidity from OTC markets to futures markets. That will be a client choice. So let's wait and see. The market will decide there. One observation from this morning was that it's interesting that with all those regulators around the world, not once was futurization mentioned as a cure for the issues that we've been struggling with, and that's because I think there will always be a substantial OTC market, and Chairman Gensler himself has said that often. So that's, we have to cure the world for that OTC market, even in its somewhat diminished form, it will still exist.
Thank you. I mean, you raise a very important point, and I want to maybe ask the group if they have any thoughts on that. And one of the issues or concerns from the cross-border guidance proposal in the definition of a U.S. person is looking to non-U.S. firms that are either guaranteed by a U.S. company or under common ownership or control of a U.S. person. The INTERP on October 12th excluded those two parts, again, on a temporary basis. But is, from your perspective, from a risk perspective, obviously Dodd-Frank talks about systemic risk and trying to minimize or reduce it. Should a non-U.S. firm, non-U.S. person that is guaranteed by a U.S. company or under common control be brought into the definition? Or, again, I go back to the October 12th definition, which excluded it. Is there any way to bring that in your view, or should they be not brought in? No one wants to touch that.
Well, can we distinguish common control and
Okay,
guarantee? I mean, I think they're
define it.
both problematic. Many of us work for multifaceted, diverse financial institutions who are based around the globe. It is often the case that when a global institution has a liquidity crisis, that becomes a global liquidity crisis. But it's not it's not essential. We lawyers work very hard to make sure that those affiliates are separately managed, they're governed by separate laws. I simply think it's just a bridge too far to say that because you're part of an integrated financial institution that you are, it's just, I don't understand it from a regulatory perspective to say that you're dragged into the same regulatory structure as one entity. So I don't get that.
Richard, as a person from a global firm, can you share your thoughts?
I don't have a strong legal view on it. I mean, one of the things that was clear from this morning's session was as much what went unsaid but suggested as below the surface was very striking, and I can only begin to guess what happened in the last couple of days when we were not in the public domain. But I think of all of the areas that is most subject to what I would call a tit-for-tat reciprocity thing, this one is the easiest one for the other parts of the world to go, well, if you're going to do that, we'll do this. And I do feel very strongly that the risk of nationalistic behavior is so just below the surface on these debates. I thought this morning's conversations were broadly very restrained, balanced, thoughtful, and so on, but the bits underneath, and you only need to look at some of the nationalistic commentary that comes from the politicians rather than from the regulators, certainly sitting in Europe, please don't underestimate how close to the surface that is. There is at the client level, I talked about the uncertainty and this perception of concern about fear of the unknown. But at the political level, it really worries me that the G20 commitments are holding better than a Syrian ceasefire, but it's only just better. And that's what worries me most. I think that's why I think this is such a great initiative. It worries me we're under such a tight guidelines on time. But if we had a bit more time to work on this and sort of try and get the clock back to the sort of level of cooperative behavior that we had pre-08 in IOSCO, where there was so much attempt to find efficiency and sensibility in what we were trying to do, I think we would be far better positioned. I can't comment specifically on this individual rule about conduits, but I do feel this of all areas is one that is most subject to a political tit-for-tat.
Steve, do you have any thoughts?
I'd agree with everything that Richard just said with regard to the possibility of outbreaks of nationalistic behavior.
One of the questions I want to raise just on U.S. person, and then we'll go on to the substituted compliance part. And again, Dodd-Frank, one of the principles of Dodd-Frank is to reduce systemic risk, and I think that's what pretty much led to the mandatory clearing And as we learned this morning, almost every country around the world is going, they may not be there yet, and we're not really there yet, but they're all going toward this mandatory clearing. So if you're going to clear the swap, let's just talk about swaps, you're going to reduce, in my view, a lot of the systemic risks. And so if you clear the swap, even if you're a non-U.S. person dealing with a U.S. person, so we might have this cross-border issue, but if the underlying swap is ultimately cleared, either here at a DCO here or a CCP somewhere else, is that clearing concept sufficient to not count that swap toward the de minimis test? In other words, should the $8 billion really deal more with a uncleared swap world, or should a cleared swap be included or not included in this, quote, de minimis test? Anyone have any thoughts on that, Brian?
I think you raise a very interesting point, and I'm, going to go back to what we've done on the energy markets. That these products have been recognized at the CME Group, as futures. The way of getting the trades into the system may have been a bit different, but be that as it may, those trades were always brought into a centrally cleared environment, and so the risk management and the risk management concerns that Dodd-Frank, evolved as a result of what didn't exist in the bilateral markets were there. Yet we still have these situations where people are concerned about the de minimis standard applying, and what's the point of that de minimis standard as these transactions are moving into that clearing mechanism and always have. So it's a great point that you raise.
Chuck, any thoughts from your perspective on going to a cleared environment should be the main focus and not whether or not you have 8 billion or 6 billion or 100 billion?
I don't really have a view whether which swap should count toward the de minimis or not. I guess I do agree that, I think the primary goals of Dodd-Frank remove systemic risk, increase transparency, whether you talk about that from a post-trade standpoint or a pre-trade standpoint. I guess at a high level, as an operator of multiple regulated entities around the world, our concern is just around the level of prescription in the rules generally. I mean, and that goes beyond just swap dealer definitions, and it applies to the U.S. and Europe, because we haven't talked about this today, it's not on the agenda, but given that it's a form of international regulators, some of whom we're regulated by, we've got a lot of overlapping, conflicting regulation, particularly at our clearinghouses. And so the whole equivalence thing and recognition we've talked about with regard to swaps dealers, and I think is good with regard to exchanges, foreign boards of trade, could use a little work on the clearinghouse, and because you can see more conflicts coming down the road as the ESMA provisions move along. So a little off topic, I apologize, but I don't really have strong feelings on your particular question.
Sorry, George?
From the point of view of systemic risk, I think it should be noted that managed money in the foreign exchange market trades on a fully margined basis, and the margins tend to be at least as high as on the IMM. And I mean, I think if you're going to, I think your point about if a swap is liquid enough to be traded on an execution facility and then can be cleared, then you've got something that is really akin to a futures contract and is margined. But I think that probably the more important point is that it's margined. In the foreign exchange markets, very, very liquid, not centrally cleared, and we trade on margin. I mean, we get margin calls, and I mean, I think that kind of trading should certainly be excluded from from the de minimis rule.
Bob, do you have a comment?
I was just going to say that if your question is, should an entity be required to register as a swap dealer and comply with all of the attendant regulatory obligations of a swap dealer because it is engaging in the activity of entering into swaps that are immediately submitted to clearing and are cleared, I think if you step back and you look at the purposes of requiring registration, the question answers itself. The statute proposes regulation of swap dealers for, I think, two general buckets of reasons. One is to manage and control systemic risk by requiring them to be overseen and have capital requirements and effective risk controls, and also for transparency and risk disclosure. And I think if all an entity is doing is cleared swaps, both of those are taken care of in that clearing mechanism, that simply by clearing the swap, you effectively manage your exposure, you're required to margin the transaction, you get the transparency of clearing it through a cleared environment where there's a clearinghouse daily mark-to-market. The counterparty would also have to clear the swap and enter into clearing documentation where it would receive disclosures. So I think from that perspective, the policy argument doesn't really hold up very well in that context.
Sorry, any other thoughts on U.S. person, or are we beat the thing pretty hard? So anyone else by U.S. person? So the second topic that we had raised for discussion, and a lot of it was discussed earlier this morning, so I'm not sure. Let's throw it out for open discussion. What more is this, quote, substituted compliance aspect, and we've already been talking about it. And I think the gentleman from Emir from European Commission talked about we need to work together, meaning all the regulators from around the world need to work together and come up with what those standards or tests are for the comparable regulatory structure. But does anyone have any thoughts? Is that the right approach? Any thought of who should have the, just how do you determine this comparability? Anyone have any thoughts on that? George?
This is not a cosmic thought, but it seems to me that the thing that has turned out to be the most important in comparability is bankruptcy law. Very incomparable.
Well, I can talk all day on that point, so I'd be glad to. Sorry, any other thoughts on substituted compliance, Gerald?
Yeah, I think the only comment I would have, I mean, it was addressed very extensively this morning, but I looked at the swap data reporting substituted compliance, and if the different jurisdictions could allow direct access to the Commission, then that would be pretty reasonable. But then, as the opinions went around the table, it became clearer and clearer that it wasn't such a simple solution. So taking the most simple, in my opinion, use of that benefit, and then you hit the privacy laws, it just really uncovers how complicated this is, especially given all the gaps that there are between the different rules.
I think you raise a very important point, and one of the issues that regulators around the world have to deal with, and they've been going through or implementing memorandum of understanding among the countries, and part of those MOUs is really to share information. And to the extent the world can share more information through the MOUs, I think it's a better world and provide greater, as Emir said, we're trying to close those loopholes, and that's a very important way of doing it. But anyone have any other thoughts on the details of what the I'm sorry, Dan.
Just a question with respect to secrecy laws and the sharing of information. Again, under Part 30, there have been MOUs and information sharing arrangements between the Commission and foreign regulators regarding Part 30 firms forever, or in 1987, whichever came first. But the I just don't understand why the secrecy laws are an impediment with respect to swaps when they have not been an impediment to information sharing on futures, and maybe that's just my own ignorance.
Well, I'm not a privacy expert, so I will defer, but I think there's the difference when governments share versus when private institutions or firms share. So I think the privacy laws protect the customers or individuals in those countries and prohibit companies from sharing that. I could be wrong on that. I'm not an expert. But
I would think we'd still want information sharing from government regulator to government regulator. I would think that that's what we'd be striving for. The only other point I'd make is listening to the discussion both this morning and this afternoon is that when we talk about substituted jurisdiction, or excuse me, substituted compliance, I think we have to be precise in what we mean, because I've heard the term used in several different ways here today. Part 30 involves substituted compliance. It's just that substituted compliance with a comparable regulatory regime in lieu of registration as a condition for an exemption from registration. So there is substituted compliance in Part 30. What we're talking about under the current proposal is substituted compliance for some but not all of the CFTC's requirements. So there'd be registration and some substituted compliance. So I think we have to be precise with exactly which substitute compliance regime we're talking about here. And as I mentioned earlier, if it's the proposed version of substitute compliance where firms are required to be registered and can substitute compliance for some but not all of the Commission's requirements, then it does get into this issue, whether it's the Commission or NFA or whomever, how are we monitoring for compliance with those substituted compliance rules.
Well, the key part under Part 30 is even though you don't have to comply with specific regulations, you're still subject to the anti-fraud provisions. And that's the consent to jurisdiction aspect of Part 30, that if you want to deal with a U.S. person, you may not commit fraud against that U.S. person. And if you do, you're going to consent to our jurisdiction to bring some kind of legal action, enforcement action against you. So the anti-fraud provisions never go away in any kind of comparable regulatory scheme. And you don't want to close that loophole. You want to make sure the firms do comply with all the proper approaches.
Just purely as an aside that people can use at their next cocktail party, I think Part 30 regulations also require firms to consent. The exempt firms have to consent to NFA arbitration programs if a U.S. customer has a beef. And I think we're still waiting for that first case to come in.
Richard, I didn't see you.
I'm just trying to think practically. The biggest challenge of this is all the time constraints. If we had 3 years to do this, which we did when we started this, the trouble is it's good till near. It's always 3 years rolling. We always need another 3 years. The customers need 3 years. We need 3 years. It's all, I think, constrained by the time frame. What we are facing is not new, and Jill's already listened to this over lunch. What we are facing is not new to this world. The complexity of different regulators bumping up against each other with activities that take place across border is things that we've been dealing with for the best part of 100 years. I'm thinking about the aviation industry as being probably one of the best examples. The challenges with it is if you end up with a minimum of 10 different interested parties, I use that as an example of the number of people represented around the table this morning, is to try and agree something multilaterally amongst that many people on this time frame is frankly unrealistic. And that's why we end up with the put your rules out comment, and it's the only other way you can deal with it, because as soon as you try and draft by committee, you end up failing to meet the deadline. From a purely practical point of view, at the end of the day, if there was an agreement between the US and Europe, that bilaterally would, in my view, set a group of agreed foundations around which the rest of the world could coalesce. You've already captured about 70 to 80% of the business if you just get those two regions together. And I think if there was a way to get to the point where, using IOSCO, which I think you've got the foundation stones and the forum to do it based on the work that's been done here, if we could get a set of agreed principles, and it won't solve all of them, I would say remarkably narrow to start off with, and then allow others to sign up to it. Exactly as the aviation world agrees, you can choose not to sign up to ICAO. The odds are nobody's going to fly to your country, but you have the choice. Sign up, you'll be part of the global activity. Don't sign up, expect to be left out in the cold, and you will then be subject to all the registration rules and everything that we would come in here. But it does seem to me that if we could get a bilateral agreement between Europe and the US, the rest of the world will coalesce around that. I think it would seem to be the most practical step to try and get to the type of things that we need to achieve on an absurdly short deadline that we've got.
No, I agree 100%. I mean, those are the two as you said, from the volume of business alone, that's going to deal with a lot. And to be honest, the two European Commission and the CFTC and the SEC here are pretty comparable from a timing point of view. I mean, 2.5 years ago when they were negotiating Dodd-Frank, we were here and the rest of the world was down here, but that time frame, because we all thought Dodd-Frank was going to take effect in 2011, and now we're almost at 2013. So that time gap or the regulatory arbitrage gap is closing tremendously, and I share your thoughts.
I just have a question with regard to the substitute compliance and thinking about conceptually, letting IOSCO play a role here. Do we decide on perhaps the 5 most important principles and say if you're abiding or you have laws enforcing these 5 principles that you are comparable? And IOSCO develops those sort of high-level principles and you leave it at that? Or how does IOSCO, you know?
So I think if we had 3 years, I would want to do exactly that. I would want to go back to first principles, and indeed a lot of this has been done. You guys have done this at IOSCO over the years. There have been, whatever it is, the 34 principles. They've been written. It's not new stuff. I think the problem we're facing at the moment, we just don't have the luxury of doing that. We've got 2 or 3 areas that are sufficiently challenging at the moment that they could cause major disruptions to relationships between countries and the marketplaces that are acting across border. And I would be inclined to, rather than go back to the drawing board, start with the general principles that have already been stated that many people have been part of forming, but I would focus the efforts on those areas that are causing the most anxiety here. And you, Commissioner Summers, you listed them as the agenda items in here. We know what the biggest problems are, and we've got like days left to solve them. I would focus there, and then with the luxury of time, build out from around that. If we could get a set of agreed principles around which we would operate for these specific items and get agreement just bilaterally between the 2 regions, we can go back and extend, whether it be with a view to harmonization or around general principles. I would do that later. I wouldn't go back to a grand statement of principles. I just think it's not realistic. We don't have the luxury of the time. So for me, I would just focus on the issues at hand. And even if we ended up with bilateral agreements between Europe and the US on these points here, and then give others the option to sign up, I think we will have achieved an immense amount.
Commissioner, I agree with what Richard said, and I thought it was heartening this morning from the foreign regulators that it seemed as though they would be very open to working towards that end. And IOSCO would serve as a good base for people just to start ticking through what those issues are and getting some commonality and agreement. But I thought what I was hearing this morning was they're hungry for that to some degree, just to know that substitutability actually will or can apply in this regard. And I thought that the Commission sent a very positive message in that regard, that you all were open to doing so.
Are there other issues that are not addressed in these 3 topics that we had for this afternoon, the substitute compliance, the conduit issue, or the U.S. person? Are there other issues that we have the time to discuss this afternoon? We would appreciate your feedback on. Steve?
Yeah, just one question for clarification. We're all talking about this extremely aggressive timeline. What exactly is driving that timeline? Is it the G20 commitment? Because many jurisdictions will miss many components of that commitment. Or is it that there is a US CFTC rule event at the end of this year?
It's the election.
I'm probably not the appropriate person to answer that. The staff that sat through the meetings for the last 2 days could answer that, I'm sure, better. I do think it has something to do with the FSB being part of this dialogue and asking the countries, the G20 countries, to identify the gaps and the inconsistencies, and that asking them to have that done by the end of this year, because that's the deadline that was in the commitments. So I think that's part of it. I don't know, Dan, if you have any idea about the timeline and what, if there's something more to it.
Right, we would, as Commissioner Summers says, talk about to identify inconsistencies consistent with the G20 and see if there are other areas where we can have some agreement and principles going forward.
I guess my question is more the ramifications. Is that if we can find a little bit more time and get it done properly by the end of March, isn't that better than rushing, try and cobble something together in the 26 days mentioned by Patrick if you take a long holiday at year end?
Well, I'm under the impression that the deadline is merely for the identification of the gaps and inconsistencies. It's not for a solution to all of those problems. Is that accurate?
That's correct. This would not be the final answer to all of the problems. This would be a critical step going forward to see what we have agreement on now and potentially steps going forward to how to address other issues. And this is these very issues are what's actually going to be discussed, and what can we agree on now, what are the inconsistencies we need to address now, what can be done later. So all this is part of what's being discussed.
Bob?
So Dan, I'll take over Ron's role and ask you a question now that you've sat down next to me. No good deed goes unpunished. Does that mean? I mean, I think part of the concern here is that roughly on December 29th there will be a multitude of entities that will have to register, and as part of registering, they will have to submit compliance procedures on how they are going to comply with various rules, and yet we don't know who's a U.S. person. We don't know how a swap transaction cross-border between a dealer in Europe and a dealer in the U.S. is going to be regulated. There are so many unknowns. Does that mean that the Commission is prepared to give people an amount of time where they will not have to comply with those requirements, notwithstanding the fact that they have submitted their registrations?
Let me provide a staff answer, obviously only at staff level on this. Those are all very relevant questions and good questions that staff here in the agency is discussing amongst ourselves as we prepare to make recommendations to the Commission and how to deal with the transitional issues. I would say that as we have faced these questions, we came up on the October 12th deadline, a number of no action relief granted a number of areas to enable the transition to occur with respect to how certain swaps would be counted towards the registration requirement. And as we come up with the December 31st deadline, the questions you've raised we're very much aware of those. The Commission, in a number of documents, in a number of instances, previously stated its commitment to ensure an orderly transition, and where appropriate and where the need has been identified, the Commission in certain instances in terms of exemptive orders, the staff in other instances in terms of no action letters has taken a number of actions to ensure the orderly transition. So yes, those are exactly the questions we're looking at, but I would say to date that we've attempted to be responsive and attempted to ensure that the transition does occur in an orderly manner. Where there's a technical necessity, where there's questions, we have provided additional time. On the other hand, it hasn't been just a blanket. We'll give everybody more time. We've tried to do it on a very case-by-case basis where the need has been identified.
And I think timing is of paramount importance here, because people are genuinely trying to come into compliance with the Commission's rules, but it's extraordinarily difficult to put all this in place. It's a very, as you know, a complicated regulatory regime, and when you're looking at unanswered questions about who has to register, what rules apply to what transactions, done where, by what employees, with what counterparties, it becomes an incredibly difficult puzzle to try and solve to do what needs to be done to come into compliance with the rules. And I think that giving people additional time is absolutely essential to avoid market disruptions, and I think also the unintended consequence of having the implementation of the regulatory regime pick winners and losers in the market evolution. I think people talk about level playing fields, and I think timing is probably the most critical element in ensuring that regulators are not inadvertently picking winners and losers as the market adjusts to the new regulatory environment.
Okay, so I want to ask a question of my two lawyers, Bonnie and Bob. So one of you had done any thinking on this issue, and the issue, a question is, obviously, swaps are traded so much differently than futures. swaps, you might have one party negotiate the swap, but it's booked in another entity, and that's what we call the conduit theory. And then one of the issues raised by Commissioner Summers on the regulation of conduits, is it proper to regulate both? Is it proper only to regulate where the swap is booked as the entity for purposes of regulation? The firm that, quote, solicits, negotiates the swaps? From a regulatory perspective, policy perspective, what's the right answer? Bob?
I think you have to go back to the primary purpose of the regulations. And, the regulations are for transparency, safety, and soundness, and to some degree, customer protection, although I would argue that that may be overstated in an institutional-only market, but I think it's still a valid consideration. And so the question is, do you need to regulate every single person in every single location that might have anything to do with the transaction? And my answer would be no. You need to regulate it appropriately to achieve the goals of the regulation. I mean, to step back to a futures or securities environment, there are firms active in the market now that might have back office systems in one place. They have employees in different places than their corporate headquarters. They may be facing counterparties in different locations. Over time, the system has evolved to provide registration requirements and exemptions and exceptions to those requirements. I think the challenge here is that we're doing all this in a big bang when you've got a pre-existing global market, as others noted this morning, and global regulators are trying to come up in one fell swoop with a regulatory regime for that market. It makes it very challenging. But I don't think you need to. I think it's going to create more problems if you try and get the last 5% of what might be out there in bringing it under your regulatory umbrella, and you're going to get a lot more bang for the buck and a lot less disruption if you focus on the first 50%.
Bonnie?
Well, and I do think, we said a little bit of this before, but I think in their ultimate sense, the conduit rules are focused on people who are trying to use some kind of surreptitious means to get out of the scope of Dodd-Frank, and because ultimately they're backing off risk to a U.S. person. But one great thing about Dodd-Frank is there is significant, clear, black and white anti-evasion authority. And I really think that, at least at this point in the process, as Bob talks about, where we're launching so many things all at once, I don't know that the conduit analysis is essential for startup. It feels like it's trying to make sure that you have every possible base covered, and instead maybe we should allow Dodd-Frank to take off with what's obvious, which is when U.S. swap dealers deal with U.S. persons directly. And then if you guys as regulators feel at some point in time that there are significant abuses because of the kind of things that the conduit rules are designed to affect, that can be the subject of later interpretation. But you're certainly not, the CFTC is not left unprotected against some of the things that the conduit rules are designed to do. So, and I do think that, as all the comment letters on this topic have pointed out, there are very legitimate reasons why, for risk management purposes, either on the part of our clients or on the part of firms like Goldman Sachs, why people would back off risk into other entities that have nothing to do with evasion of Dodd-Frank and merely have to do with centralization of risk. Again, both from a client perspective and from a swap dealer perspective. So I'm surprised to see them at this stage in the rulemaking process, because I think they're chasing at something that may not actually be a problem at all.
Thank you. Commissioner Wiegand, do you have a question?
I did. Bonnie, I think, mostly answered it, but it was actually more related to the discussion surrounding the prior question about registration. And the question was a fairly simple one, and it was if firms have to come in and register, and maybe Dan Roth has some thoughts about this too, I think you can have sort of a phased-in approach with respect to compliance. You could come in and register, present to Dan's group some plan for complying with your entity level and transaction level requirements as they relate to dealing activity with U.S. persons under the no action relief definition. And then later, basically amend your compliance plan. I imagine come to the NFA again, update your compliance plan. Once the rest of the discussions through IOSCO and the FSB and otherwise are completed, and there's more coordination among all the different regulators about how to deal with these cross-border transactions. I guess so. With that as sort of background, the question is, that doesn't strike me as a terribly unreasonable approach, even if it would require registration, sometime relatively soon. It would require basically updating your compliance plan more. You'd have to do it at least once. You'd have to, demonstrate how you comply with your transactions or with the rules with respect to transactions with U.S. persons, and you'd have to come up later, approach the NFA, and once this other process, this international process is complete, make a new demonstration at that point. It doesn't strike me as a terribly unworkable way to do this, but I guess I ask that in the form of a question. Is it?
I can tell you from our point of view, it would just simply be a question of stretching out the period of time in which the 4S submissions have to be made. And there'd be a smaller set of 4S submissions that had to be made initially. Provisional registration would be granted. The provisional registration would stay in place for a longer period of time, and it wouldn't convert to a full registration until a later date. That's certainly not a problem from a processing point of view.
I think there are two interrelated questions. One is, when do you have to comply with the rules, and what rules do you have to comply with? And I think your approach is a very good solution to when you have to comply with the rules. I think there's an underlying issue that we've all been sort of talking about is, what rules do you actually have to comply with? Are all of the proposed and final rules necessary to accomplish the G20 commitments and the statutory goals? And I think that's a somewhat different answer. I mean, I would argue that, and I was interested to hear Robert Cook's comments this morning about how they are actually looking at the data that's now available through the SDRs in fashioning their regulatory regime. I think the commissions have the luxury of this impending flood of data from swap data repositories, and if there are concerns about whether there's evasion through conduits or through other aspects, you're going to have data to be able to look for those kind of things. And maybe the answer is, rather than trying to adopt a prophylactic rule that has unintended consequences now, you hold off, you look at the data, and if you think there's a problem, then you can address it.
Okay, I know there's a storm brewing up in New York, and I know many of you need to catch a train very quickly. So let me just conclude or ask one question around the table. And I'm going to wave or just say I'm going to assign a magic wand to each of you. And each of you have the right to pick one rule of the cross-border guidance proposal that you would like to see changed. Okay? One rule, and one rule only, not two. What rule would you say, what are the comments you want to share with the Commission? What is the most critical issue that you see among the cross-border guidance proposal that you believe should be modified or changed or removed? Bonnie, your light's on from before, so you're stuck with it.
The only way I can answer that is I think the agenda that you and Commissioner Summers picked for this meeting was perfect. I mean, I think the U.S. person definition is very problematic as proposed. I think the focus on rule-by-rule substituted compliance at a firm level is concerning and actually not consistent with the Commission's approach to global regulation previously. And I think there are a number of rules, with the conduit definition being one example. I think some of the regulation of companies based on common control or things like guarantees are also examples. But I think that just the general overreach of the statute or the proposal beyond, what is obviously within the scope of Dodd-Frank is a concern. So, sorry, that's a bit of a cop-out, but I think you guys got it right. I think these were the right issues.
Jim, your thoughts?
I don't know if there's one rule to get rid of, but I think Richard's point was valid earlier, is finding some consensus maybe around the leading regulators and working forward in a smaller fashion to resolve them. I think, maybe reiterating what Richard said, don't bite off more than you can chew initially, but let's find what's the 3 salient points or 5 salient points, and find consensus with the EU and bring others in to comply or to agree or not. So I think that would be the approach.
Thank you. Steve, any thought from your perspective?
Same as him, actually. I think substantive compliance, and got the feeling today that the EU is pretty convinced that they've got a fantastic rule. So let's sit down and work with them, work out what's wrong with that, and partner with them to come up with some rule that's going to make sense for everybody.
Thank you. Gerald?
You said magic wand, right? So I'd suggest line up the dates to the international regulations. So why election happened yesterday? We know the results. Now let's line up the dates so we all can see each other's rules and pick the right date. I think the date is more important than the gaps, which we'll never fill because it's principles-based internationally versus more rule-based here. So I think it's going to be very hard to close those gaps.
I take back my answer. I want all regulators globally to move to the same rule book on the same day.
Dan?
Just to follow up on a point that Dan made, to the extent that continuing uncertainty requires the Commission to push back certain deadlines, the sooner that's pushed back, relief granted at the 11th hour doesn't relieve anxiety quite as much as relief granted at an earlier time. So if that's the direction we're moving in, and I don't know that it is, but if that's the direction we're moving in, something prior to December 30th would be a good thing.
Chuck, from your perspective?
I guess I would just repeat something I said earlier. This theme of mutual recognition and equivalence with regard to participant registration or swap dealer regulation, equal focus on leveraging that international cooperation with regard to clearinghouses and exchanges, given that both U.S. and in Europe, new core principles with financial reform are ever more prescriptive on both those institutions. So there's an increasing opportunities for clearinghouses and exchanges to be caught with two different requirements from two different regulators to serve the same global market.
Thank you. Bob?
Being a lawyer, rather than answer your question, I'm going to incorporate by reference the sources for the answer. I jotted down some notes of things I wanted to mention today, and I was pleased and somewhat surprised that as I was listening to this morning's discussion, I ticked all of them off. So I think this morning's discussion is incredibly helpful. And I would also note that my institution filed its own comment letters on both the ET guidance and the exemptive order. We really tried to make those comments short, concise, and constructive, and I would just point to those.
I thought you were going to say you want all swaps converted to futures so you don't have to negotiate any more addendums, but I guess I was wrong. Brian?
It's repeating everything that everybody said, but just some clarity on mutual recognition. I think that there was, definitely some representation in the cross-border release. We believe that it makes, absolute sense. We're very supportive of it, but I think hearing around the table this morning, we need to really work towards providing that clarity as to what that means to the foreign regulators, and we need to make sure that reciprocity is included in that context as we look at approval of foreign CCPs and how reciprocally we're treated in that regard.
Thank you. David?
Just like Richard mentioned, that this is one part of the world where people can do tit for tat. Earlier, Emo mentioned that, and he really pointed out that they were prepared to be flexible. And I think it would be a perfect time for us to reciprocate.
Thank you. George?
I think that this tsunami of registrations that Dan is going to have to deal with could be limited a little bit by saying that the $8 billion rule doesn't apply to exchange traded and cleared swaps or margined swaps.
Thank you. Richard?
I've got only a single piece of advice, and that is that I think if we made the process a little more iterative, and I think, as Bob said, we were focused on the big things that mattered up front, get them in place, and then essentially suck it and see. We've got all the luxury in the world of catching these other things, which I think staff at the moment are understandably concerned about, but we've got the luxury of cleaning them up as the time goes by. I think we are trying to do too much in too short a period of time, and I don't think we have to get to 100% perfection. If we can get to 90% now and fine-tune it, I think that will be great. I think a lot of us underestimate how Dan's world, the CCPs, the exchanges, the amount of new things we are trying to do are enormous. And I certainly, sitting on the board of one of the large exchanges, clearinghouses and CSDs in Europe, do not underestimate the level of responsibility that we have on our shoulders to be able to execute this properly. And it would help immensely if we can keep stuff simple, and then as we learn more, adjust rather than try to get perfection on day one. And therefore, iterative is my single word of advice.
Commissioner Summers, I'm sorry.
No, it's okay. I just wanted to say thank you to all of the GMAC members for sitting through not only this morning, which I thought was a very productive discussion, but being here this afternoon, spending the whole day with us to help us get all these issues right. So I appreciate all of your participation.
Let me echo your sentiments as well. Thank you all to the GMAC members. Ron, thank you for your help today facilitating this. The one takeaway today, Mr. Kono said it regarding the commission rules. Direct and insignificant is way too broad, and the substituted compliance is way too narrow, and we have to bring that together. That has got to be reconciled, and I think that was reflected in a lot of your concerns here today. That was obviously reflected in the concerns of the international regulators, so that's my takeaway. So, Commissioner Summers, thank you very much for doing this.
Commissioner Wheaton, anything, or Diane?
I just want to echo what else has been said by the others. Thank you, Jill, for putting this together. This is extremely useful, very, very helpful.
So before we just conclude today's session, I do want to thank all of you. And as I said earlier, I'm very humbled and honored to be here. And I look at this as a partnership, joint venture among Commissioner Summers, myself, and all of you. And I think some of the things we need to think about going forward is what are the other issues that are of interest to this group? You are the best and the brightest in the industry, and I hope we can come up with some other new concrete proposals down the road. And I've always been a big customer asset protection, and George mentioned it earlier. I mean, one of the lessons we learned from Lehman is that the bankruptcy laws around the world we can't change that. It requires parliaments around the world to change those laws, but those are critical issues that we might want to deal with from a topic perspective and just start that discussion. But if you have anything else on your plate that you think would be of interest to this group to discuss, if you could just send those thoughts to Commissioner Summers and myself, and we'll try to put together our programs in the future. So I want to thank all of you. I thought it was a great discussion, not only this afternoon, but this morning. And I hope all of you have some safe travels, especially those of you going back to New York. Thank you very much.